The next item of business is consideration of Business Motion 15884 in the name of Jamie Hepburn on behalf of the Parliamentary Bureau on a Stage 3 timetable for the Scottish Elections Representation and Reform Bill. Any member who wishes to speak to the motion should press their request to speak button now, and I call on the Minister to move the motion.
Move, Presiding Officer.
Thank you. No member has asked to speak to the motion. Therefore, the question is that motion 15884 be agreed. Are we all agreed? The motion is therefore agreed. The next item of business is Stage 3 proceedings for the Scottish Elections Representation and Reform Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is Scottish Parliament Bill 42A, the marshalled list and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division of the Stage 3. The period of voting for the first division will be 45 seconds, and thereafter I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press their request to speak buttons or enter RTS in the chat as soon as possible after the group has been called. And members should now refer to the marshalled list of amendments. So we move to Group 1, disqualification. I call Amendment 34 in the name of Graham Simpson, grouped with Amendments 35, 36, 3, 37, 5 and 6. Graham Simpson to move Amendment 34 and speak to all amendments in the group.
Thank you, Presiding Officer, and I move Amendment 34. It's an absolute pleasure to start off our deliberations of Stage 3 amendments with this group, which contains 3 of mine and some from Annie Wells and my new friend, Ross Greer. I'm happy to support the amendments from Mr Greer, and I look forward to hearing from Ms Wells about hers. Now, it's fair to say that my 3 amendments have attracted a good deal of attention. They aim to tackle the issue of dual mandates, which, as members know, is the practice of holding positions here and in the Commons, Lords or Councils at the same time. This Parliament is alone in the devolved legislatures in allowing it, and it's high time it ended. I read the Standards Committee's excellent Stage 1 report, and it mentioned the issue of dual mandates because it had come up during their evidence-taking, and the majority of submissions to the committee on the matter said dual mandates should end. During the Stage 1 debate, I was clear that I would be looking at it for Stage 2, and I also said that there are different views on the issue. But I'm certain that the vast majority of the public and most of this Parliament agree that we should ban so-called double jobbing. The fact that we haven't is an oversight that is hard to fathom. It's one of a number of legislative gaps, some of which I'm attempting to fix with my Members' Bill, which members will be pleased to know is due to be published tomorrow, along with screeds of accompanying documents to keep you all busy over Christmas. Now, I kept my word, and at Stage 2, I submitted a series of amendments that looked at dual mandates as they relate to MPs, members of the House of Lords and councillors. The Minister then wrote to the committee saying that he wanted to consult on the issue, but said there would likely be no legislation on it before 2026. I spoke during the Stage 2 debate, but tactically withdrew because A, I wasn't going to win that day, and B, because I knew I might get another chance with a bit more thinking, discussion and persuasion. And that is exactly what's happened. But we also have a certain MP to thank who came out of the woodwork to say that he wanted to stand for this place and continue to be an MP. There may be others too. And that spurred me into action again and told me I was right to pursue this. So I tabled new amendments. That and the furore over the said MP's ambitions have forced him to back down. And if oh yes, I'll take an amendment. I'll take an intervention.
Keith Brown.
Can I thank Mr Simpson for taking the intervention? And I'm really just looking for his view on this, because obviously if this amendment was to pass, the decision would rest with ministers. But is it his intention, and does he support the idea, that the disqualification to be a member of this Parliament should apply at the point of nomination, or does he think it should apply only if somebody is elected to this place? Because if that was the case, that would necessitate a by-election with all the attendant costs. Which is his preference, to be disqualified at the point of nomination or subsequent to election to this Parliament?
Graham Simpson.
Well, I'd encourage Mr Brown to read the amendments. What the amendments do is leave the details to regulations, and the Minister will be consulting on that. It's not my intention to stop anyone from standing for this place. I would never do that. If somebody wants to stand, let them be elected. But the regulations for this, which is clear in the amendments, if Mr Brown would read them, I'm sure he's got them in front of them while I'm speaking, then the details will be left to that. Now, yes, I will. I'll take another intervention.
Stephen Kerr.
To build on what Keith Brown has asked, can I ask my colleague what discussions he had with the Minister about the expected timetable of any consultation? Would it be, in my friend's estimation, that this amendment would play a part in the selection of candidates in 2020 for the 2026 election?
Graham Simpson.
Well, can I thank Stephen Kerr for that intervention? I'll just say to Stephen Kerr, the Minister has been very clear on this. He gave a statement last week. He set out his timetable, and I'm sure he'll repeat that when he makes his own contribution. But his intention, I'm not speaking for the Minister, he can do that himself, but his intention is that all this will be in place for MPs and peers by the time of the 2026 election. I hope that reassures my friend Mr Kerr. Now, we had the furore over the said MP's ambitions. That forced him to back down. And I have to say, if all that has helped Audrey Nicholl, who is a lovely lady, then I'm absolutely, I'm delighted. I am delighted about that. Now, I'm not naming the MP because he would probably like me to, but we all know who it is. This is not about him or anyone else, but he has helped to shine a light on double jobbing. So he's done us a favour in a way, though it might not have felt that way to some. Now, I want to give the debate around these amendments some context, so let me turn to what has gone before. I've said that Scotland is an outlier in not banning dual mandates. So first, let's have a look at Northern Ireland. Dual mandates between the House of Commons and the Northern Ireland Assembly are prohibited by the Northern Ireland Miscellaneous Provisions Act 2014. That was a UK Parliament Act. This provides that an existing MP elected as an MLA has 8 days to resign from the House of Commons, while an existing MLA elected as an MP must resign immediately from the Northern Ireland Assembly. And the Act also explicitly prevents members of the Legislative Assembly from becoming members of Parliament in Dublin. The Local Government Act Northern Ireland 2014 prohibits councillors from being members of the Assembly, House of Commons, House of Lords, or elected to any other legislature. And the banning of dual mandates in Northern Ireland followed increasing criticism of the practice in the aftermath of the 2009 MP's expenses scandal. That year, Sir Christopher Kelly published a report into MP's expenses and allowance. This recommended that the practice of holding dual mandates in the Commons and the devolved parliaments should be brought to an end as soon as possible. The Kelly report found that so-called double jobbing was most prevalent in Northern Ireland, where in 2009, 16 out of 18 Westminster MPs also sat in Stormont, 5 of whom were ministers. The report found that double jobbing was unusually ingrained. Yes, I'll take Mr Johnson.
Daniel Johnson.
I'm very grateful to Graham Simpson for giving way. I mean, I think in some ways he sets out a very good case in terms of the precedent elsewhere. Can I ask, though, why he's limited the scope of his amendments to the House of Commons and the House of Lords, and he's not looked at people with dual mandate with this legislature and other devolved legislatures, or indeed bodies such as the Greater London Assembly?
Graham Simpson.
I think Mr Johnson makes a reasonable point. Perhaps that was an oversight on my part, but I think the main issue for us, to me, the main issue is MPs who want to sit here as well as being MPs and Lords as well. Councillors, of course, and I'll come on to that, councillors is another matter, but I'll come on to that. So that report said the committee questions whether it's possible to sit in two legislatures simultaneously and do justice to both roles. And David Cameron pledged to end dual mandate for Northern Ireland in the 2010 Conservative Party manifesto. This was framed as part of a broader objective to make devolution work and bring Northern Ireland back into the mainstream of UK politics. Now, in Wales, dual mandates were banned under the Wales Act 2014. This ruled that any MP elected to the Senate has 8 days to resign from the Commons, while an existing AM elected as an MP must resign immediately from the Assembly. The Secretary of State for Wales justified these changes as a response to the increased workload of AMs following the 2011 devolution of powers. And in a debate about Welsh National Assembly elections in the Lords in June 2012, Baroness Morgan of Ely argued it is difficult to serve two political institutions at the same time, and I agree with that. The Senate and Elections Wales Act 2020 disqualified members of the Lords, Scottish Parliament, Northern Ireland Assembly or local authorities in Wales from being members of the Senate, which is possibly the point that Mr Johnson was making. So in Wales and Northern Ireland, we have legislation to prohibit double jobbing, but not here. Somehow Scotland has escaped. It does not make sense. Yes.
Douglas Lumsden.
Thank the member for taking an intervention. He says that we have to obviously put legislation in place in this place. But would Westminster have to put some legislation in place also to really stop double jobbing by stopping MSPs then standing for Westminster?
Graham Simpson.
Well, I would just stress to Mr Lumsden, I'm not trying to prevent anyone from standing anywhere. It is the practice of continuing to serve in two places at the same time, and these amendments would tackle that issue. So in this Parliament there is a petition on the issue. The Electoral Commission for Scotland gave a submission on it, which they said, quotes, "We would like to see the legislation here brought into line with the Senate. Having a full-time paid job in the Lords, Commons or Holyrood should be mutually exclusive, and we would advise against MSPs being allowed to hold dual mandate. There are no clear advantages to voters or to the operation of democratic institutions, and one big disadvantage: the capacity of an individual to fulfil the responsibilities of both roles." And we've also seen support from none other than my other good friend, Ivan McKee, who said, "I think double jobbing, work as an MP and an MSP, isn't sustainable." And Scottish Secretary Ian Murray told the Scottish Affairs Committee on the 20th of November this year, "Everyone around this table knows how hard it is to be a constituency MP and then have other responsibilities as well. I would think the Scottish Parliament would want to look at this." Now, as I said earlier, at stage 2 of this bill, the Minister for Parliamentary Business said he wanted time to consult on potential changes. That could have meant no legislation being in place until the 2031 elections, if at all. Now, that might suit some people, but it's not acceptable to me. And we have the chance in this bill to act now. I originally tabled 2 amendments. Yes, of course.
Minister.
I mean, he would recognise, of course, that I did not shy away from that fact, and indeed I was explicitly clear with the committee in recognising that my preference for consultation at that stage would, if we had sought to legislate by the primary legislative route, indeed have led to such a delay. I didn't demur or hide that fact at all.
Graham Simpson.
I agree with that, and I have to say, and I'll probably repeat it later, it has been a pleasure to work with the Minister on this, and I think we've arrived at a sensible conclusion. If Parliament backs our joint position, that would be a good thing. Now, I originally tabled 2 amendments for Stage 3 to this bill, dealing with MSPs who are also MPs and MSPs who are also peers. They were a belt and braces approach, and while they would have attracted widespread support, I wanted to get the Minister on board. So rather than go for the purest option, I came up with something more pragmatic. So I'm asking Parliament to vote on the principle of dual mandates in relation to MPs and peers, with the details being left to regulations that the Minister has agreed will be in place before the 2026 elections. I'm sure he's going to repeat that today. That's what Amendments 34 and 35 do. Amendment 36 says that the issue of whether councillors should be able to do both jobs can be dealt with in regulation if consultation shows there is a case for it. And I'm closing, Presiding Officer. At the heart of this is the principle of whether you should be able to serve here as well as another legislative chamber. For me, the answer to that is no. This is not a cosy club. This is a parliament, and we're here to serve the people. This is not a second-rate chamber to be used as a part-time hobby. This is a serious parliament, and members should be fully focused on their work here. Being an MSP demands our full attention. It is a full-time job. We make laws for the people, not to protect the vested interests of individuals or parties. The amendments I'm proposing today stand up for this Parliament and the standing that it should enjoy. Double jobbing should be consigned to history. David Cameron was clear that double jobbers, quotes, haven't got a leg to stand on. He legislated for Northern Ireland. Wales has legislation. We can legislate here. We should do the right thing, and I move the amendments in my name.
Thank you. And I now call Annie Wells to speak to Amendment 3 and other amendments in the group.
I probably won't go on for 15 minutes, so we're okay. I want to start off by thanking the Minister and his advisers for working with me on it and having communication with us. And as you know, I did introduce amendments which aim to prohibit all sex offenders, even those who were no longer subject to the sex offenders notification requirement, a sexual risk order or a sexual harm prevention order from standing for this Parliament or local government, and I'd put those amendments in at stage 2. And I did withdraw these amendments because of the concerns that they may not comply with Article 3, Protocol 1 of the European Convention of Human Rights, which concerns the right to stand for election. My amendments today, 3 and 37, are an attempt at compromise with those who were previously subject to sex offender notification requirement, but who are no longer under such requirements. And the amendment was required to disclose this on nomination papers to the Scottish Parliament or local government. But however, Presiding Officer, disappointingly, I have again been informed by the Minister that these amendments may fall foul of the ECHR and may fall foul of the competence of this Scottish Parliament. And I absolutely do not want to jeopardise. Yeah?
Stephen Kerr.
Grateful to Annie Wells for giving way. I think our constituents, maybe she would comment on this and whether she agrees, I think our constituents will be greatly confused by the idea that the kind of clearances that one has to go through with Disclosure Scotland, for example, to be involved in a youth club or to be involved in a role, any kind of role with children and young people, that somehow an MSP could enter this chamber elected without any kind of clearance at all, might have the most lurid background, the most unsuitable character to be an MSP, and yet you're being told it's against a convention on human rights. What about the human rights of the majority?
Annie Wells.
I thank Stephen Kerr for that intervention, and that was the reason why I brought the amendments forward. I was looking at what this meant for victims of sexual violence and sexual crimes, what it meant for parents and grandparents of children at school, and maybe a member is going into the school to visit and we don't know the background of them. And I understand as well that when people say there's been a crime done and someone served their sentence or their punishment, but I think this is a different step and a step too far. But I do think it's a valuable opportunity to talk about standards in public life here today. All of us in this chamber, as Mr Kerr alluded to, are in a position of power in our capacities as member of the Scottish Parliament, and it is important we do not abuse this power. I would therefore not be comfortable if someone was elected to this Parliament who was a former sex offender, and I absolutely respect the need to comply with their international legal obligations, but I am dismayed that they prohibit us from enacting common sense policies. Yes.
Alex Cole-Hamilton.
I'm very grateful to Annie Wells for giving way and for bringing this debate this afternoon. Annie Wells will remember that in the last session of Parliament in which we served together, I brought amendments to previous pieces of legislation to talk about the Protection of Vulnerable Groups scheme applying to elected members. I think that's still an unanswered question, and I think she is very eloquently putting the case as to why it is an unanswered question. And it's not just on grounds of sexual offence either. The PVG will always pick up things like crimes of dishonesty as well, because remember, in our privileged roles of members of Parliament, we are dealing with sometimes very vulnerable adults. And of course, we would seek in our constituency safe casework surgeries to have safeguards to ensure that we were never alone. But that doesn't presuppose that everyone will always take those steps. I have toyed with this amendment. I've grappled with this amendment, particularly Amendment 37. I have one anxiety, and this is the point to which I'll come, is that actually Amendment 37 talks about sexual offence orders that have been disapplied. And in a lot of cases, that's absolutely right that we should know about that information. But in a small number of cases, this applies to minors who've, through, I think, either repetition of abuse that's happened to themselves or through other acts that they've perpetrated as young people, have had that risk of sexual harm order or that sexual offence prevention order applied to them, but by, I think quite rightly, had it disapplied when they attained majority, given that they wouldn't, because of what happened to them, want to have that hung around their neck for the rest of their lives. So I have anxiety about that, and would she speak to that in the remainder of her remarks? Thank you.
Annie Wells.
Yeah, thank you. And I do understand where the member's coming from. But at the same respect, I'm looking at it from a victim's point of view here as well. If I was to get a leaflet through my door of someone who had maybe committed a sexual crime against myself or a member of my family, and they were seeking election, and they stood up in this place and were making law for us, I would feel very, very uncomfortable. And most people that I speak to would feel very uncomfortable at that as well. So that was the whole reason of me bringing forward this amendment, these amendments, which I will not be pressing today. But on my colleague Graeme Simpson's amendments 34, 35 and 36, I did say at stage 2 that changes to dual mandates needed to be consulted first. And I note that the Government have announced their intention to consult on these changes in the new year, which is welcome. And we will be supporting Graeme Simpson's amendments today. Ross Greer's amendment number 5 and 6 stipulate that when a court finds that an offence aggravated by hostility towards a returning officer, registration officer or accounting officer has occurred, the court must state if a different sentence would have been handed out without this aggravator. And these changes seem sensible to me and are most welcome. Thank you, Presiding Officer.
Thank you. And I now call Ross Greer to speak to Amendment 5 and other amendments in the group.
Thank you, Presiding Officer. And I should say from the outset that my contributions in future groups will be far shorter than in this initial one. And I want to start off where Annie Wells just finished on my amendments on aggravators. And I brought these forward because I believe that democracy is under pressure across the world at the moment, not just here in Scotland and the UK, and attacks on those involved in the electoral process are unfortunately rising. We saw that during Ireland's recent elections, including, unfortunately, an assault on my colleague, the leader of the Irish Greens, Roderick O'Gorman. We saw it just yesterday with an attack on activists for the German Social Democratic Party ahead of their election in February. Amendments 5 and 6 create an aggravator. So for those who are issuing a sentence when an individual has been found to have committed an offence, if the offence has been committed against those involved in the electoral process, there's a requirement to consider application of the aggravator. There's no requirement to apply it. As Annie Wells said a moment ago, it would be at their discretion, though they would have to state if they had applied it how that had varied the sentence, and if they did not, for what reason they decided not to apply it. So Amendment 5 applies the aggravator to the category of individuals specified in this bill. So that's those involved in administering an election, returning officers, registration officers and counting officers. Amendment 6 amends the UK Election Act 2022, so far as it applies in Scotland. It applies the aggravator to the other group of people involved in elections, that's candidates, elected representatives and campaigners. And I've brought these amendments forward because I think we need more people involved in our electoral process, not fewer. And all parties, and I would think members across the chamber would recognise this, all parties face challenges in recruiting more individuals and individuals from more diverse backgrounds to stand for Parliament, and a significant part of that is because of the threats, the risks that are faced by those involved. So I propose these amendments because I believe that they are another useful tool to protect and to strengthen our democracy. They are not in and of themselves, of course, the solution to the challenges that we face, but I think they are a tool worth having at our disposal. Turning to the amendments on dual mandates, I'd like to thank the Minister and my friend Graeme Simpson for their work on these. And of course, I'd also like to thank the individual who sits elsewhere, whose recent errors of judgment have allowed us to bring these issues back for debate, because, of course, the Minister offered Graeme Simpson and I a compromise at stage 2. Rather than press our amendments, the Government offered to run a consultation on this issue that would mean it couldn't be applied for 2026, but the consultation could be conducted and we would be able to legislate on this in the next session of Parliament. Of course, events since then created the political space in which we could bring these issues back for debate now and apply them from the 2026 election. I'm most grateful to the individual whose choices made that possible. The Scottish Greens are glad to support these amendments for the simple reason that being a Member of Parliament is a full-time job. This job is a privilege, a huge privilege, but it's also immensely challenging, and it's the kind of challenge that requires dedication to the role, a level of dedication that I think we would all recognise our constituents expect from us. On the Amendment 35 in relation to the Lords, it's somewhat of a compromise on the amendment that I brought at stage 2 that would have simply banned peers outright from this Parliament. This Amendment 35, I think, perfectly reasonably includes provision that would allow someone who has a peerage to serve here for as long as they have taken a leave of absence from the Lords. Now, I focused at stage 2. Yes.
Keith Brown.
Can I thank Ross Greer for taking intervention? And if I could pose to him the question I asked of Graeme Simpson, which he was unable to answer and didn't seem to know the extent of his own amendments. Would it be Ross Greer's interpretation that this ban, if you like, on the dual mandate should apply at the stage of nomination? So you'll be aware that when returning officers receive a nomination, they can declare at that point you're disqualified, the nomination is not valid. Or is it his view, and I know that the amendment says it will be decided by the Minister in due course, is it his view that the election should proceed and a by-election should take place with all the attendant costs after the election? Just interested in his view.
Ross Greer.
I'm grateful to the member for that intervention. The amendments require a consultation and for regulations to then be developed. So that's a question that has not been answered yet. I think it's right that that question is answered after the consultation. My personal preference would be for the latter of the two options that the member mentions there. But it is right, recognising the concerns the Minister raised at stage 2, for these issues to be thoroughly consulted on before regulations are brought back to Parliament, and of course for Parliament as a whole to make a final judgment on that. I should say I focused on the Lords at stage 2 simply because I see the Scottish Greens see the House of Lords as an anti-democratic outrage, and we think that membership there is incompatible with membership of an elected body. Being an elected representative and being an unelected, unaccountable lawmaker, we don't believe to be compatible. I'm glad Amendment 36 has been brought forward in the form that it is, because unlike 34 and 35, it doesn't prejudge the outcome. 34 and 35 quite rightly use the word must. We have decided, or we will decide this afternoon, to ban double jobbing for MSPs as MPs or as peers. But I think we do need to take separate issues into consideration when it comes to councillors. So the Scottish Greens, for example, don't have an issue with the de facto situation we have at the moment of the year's transition period between the election to this Parliament and then the local authority elections the subsequent year. Given in that circumstance that the cost of a by-election are about 4 times the cost of a councillor's salary, and we think there's of course no harm in consulting on what options could be taken there. I'm particularly glad that that amendment includes provisions potentially for a transition period, for example of a year and a week, to allow for that year of overlapping mandates. Turning back to the amendments that I've moved on aggravators, I just want to finally make the point that I recognise here that there have been concerns from some members at previous stages about amendments in this space. And I would simply emphasise again the point that I made a moment ago around wanting to welcome more people from more diverse backgrounds into the electoral process. I know this is a conversation certainly my party have had. A number of women that I've spoken to in my party, who I'm trying to encourage to stand at the next election, have at the top of their list of concerns raised matters of safety and the risks that are posed to elected representatives. So I do think, given a number of the other debates that we've had in this Parliament in recent weeks, if we want to not just strengthen our democracy but make it more accessible to those currently being shut out or who feel there are significant barriers in their place, that having these tools at our disposal, I think, would be most useful. And I'll finish there, Presiding Officer.
Thank you. And I call Alex Cole-Hamilton.
Thank you very much indeed, Presiding Officer. I won't take very long at all. Just to put on record Liberal Democrat support for Graham Simpson's amendments around double jobbing. This role is a privilege. If it isn't occupying all of your waking hour and some of your sleeping hour, you're not doing it right. All of our families put up with a lot. I think it would be very difficult to try and juggle that with any other elected role, so it certainly has our support. I just want to restate the point I made in my intervention to Annie Wells, that the question of vetting not just parliamentary candidates but council candidates is an unanswered one, that we still, I think, have privilege and access far beyond what we would tolerate for people that we would deem either in a regulated childcare position or in positions of power and influence over vulnerable adults. I think it's something we should revisit as a chamber. Other assemblies do have rudimentary vetting for their parliamentary candidates. It's something we can't wait for something bad to happen before we address it in this place. Thank you.
Thank you. I call Martin Whitfield.
I'm very grateful, Presiding Officer, and as with others, I will not take too much of the Chamber's time, but I think it is worth visiting these amendments, particularly in Group 1, to set out the position, because much of the amendments that we're dealing with today are minor and technical, but Group 1 contains some fundamental questions that certainly the committee, over its time that was involved with it, and others have wrestled with. With regard to the first three, in the name of Graham Simpson, it is right to say that fundamentally we all agree that double jobbing is wrong. Anybody who sits with the privilege in this place or the privilege of sitting elsewhere knows it's a full-time job, more than a full-time job, and takes up much of the sleep rather than just small amounts of it. And again, in the spirit of Christmas and the time of the year, I think it's been very positive to see cross-party working on this. The Minister has been very open to raising errors, problems or concerns, and all the members involved in this, even though their names do not appear sometimes in support of these amendments, have worked to come up with the compromise. And I think it is worth reiterating the importance that the first two amendments with regard to MPs and to the House of Lords are a must, whereas with the councillors it is open to the consultation, which, as I did at stage one, I would urge again people to contribute to, because it is part of the rationale of how elected, or how people who choose to seek election end up in this place, what their roles are, and it is for people to contribute into that environment to make sure that the right people come to this place with the right and proper support of those that elect them from outside. So my compliments with that, and I can confirm that we will be supporting those amendments. To Annie Wells's two amendments, she's aware of my concerns about this, and I think it is right to pick up the two different points within the human rights legislation that applied at stage 2 and with these with regard to stage 3. And we did struggle as a committee, and indeed we were ably assisted with evidence very late on with regard to what the consideration should be for the disqualification of MSPs and indeed councillors who appear on the sex offenders register. It is on some levels a very complex area, but it is an area that the committee received substantial evidence that certainly reassured the committee that there are levels of protection there that are perhaps sometimes go unseen by members of the public. There are stories and there are events that sometimes call that into question, but it was an area that we very much struggled with. The two amendments that we're faced with at the moment do raise concerns with me on a human rights basis, and I think it's very admirable for Annie Wells to point out her intentions with regard to these amendments in due course, and I'm grateful that she intends to do that. But it is a discussion that has to happen. It's a discussion that extends beyond the role of parties, including this Parliament, in assessing eligibility. It also falls on political parties to make those decisions. It also falls on individuals about whether they should choose to put their names forward for this position. There are responsibilities that lie outside the statutory extent that this bill can go to, but it is one that I think all people, groups, parties involved in it should pay great attention to. To the amendments in the name of Ross Greer, I've been on swings and roundabouts with this, as I was during the committee, because this is an area that's inviting our criminal legislature to look within the elections world for whether or not it should be aggravated. But I am, and I hope Ross Greer accepts this, glad to support these at the end, because it is a matter that we are struggling for engagement sometimes from people, not because they don't desire to, but they are genuinely concerned about the experience and environment that they will fit into. And it's right that Ross Greer says this will not be the cure to that, but certainly it's a step forward to understand how important this place, and indeed how important the people of Scotland should feel about those who put themselves forward, those who put themselves forward to support them, and those who administer the situation from the polling station to the count and indeed to beyond that. So we will be supporting those today. I will, unfortunately for the Chamber's knowledge, be returning on other sections, but I'm grateful for your time at the moment, Presiding Officer.
Thank you, and I call Edward Mountain.
Thank you, Presiding Officer, and I will keep my comments as short as possible. I'm pleased to see that Amendments 34, 35 and 36 appear to get cross-party support. Before Mr Simpson had approached the Minister and reached agreement with him, he and I were in discussion because we fundamentally both agree that double jobbing doesn't work. This is a huge amount of work to take on as an MSP in this Parliament, to answer all your constituents and to deal with the businesses that you have to do here. Therefore, taking a role in another Parliament seems beyond my comprehension that somebody could do both well. So I'm therefore pleased that the Minister is going to bring some regulation forward before the election in 2026. If I can just say, Mr Brown has asked various questions on when I think, or when people think that that should take effect. I believe that on election it should be when you have to stand down. You have to make a choice at that stage whether you serve in one Parliament or the other. To ask you to stand down before, I don't think is right. On Amendment 36, sorry, an intervention from Mr Whitfield. Sorry, I didn't see that.
Martin Whitfield.
I'm very grateful to Edmund Mountain for taking an intervention. The amendments are very clear that it's about membership of this place rather than any process before that membership exists.
Edward Mountain.
I think it is, and I think that's why it will be beholden to the Minister to answer that when he comes to it. But on the issue of Amendment 36 and councils, I struggled with this while we were discussing it before agreement had been reached, because there is at the moment only a small gap between when you're elected to this place if you're a councillor and when you have to stand down. And the cost for carrying out a council election at short notice, when perhaps you've been in for just a short while, we know too readily at the moment, are quite high. So I'm not swayed on councils, but I am swayed on the fact when it comes to serving either in this place or in Westminster or the House of Lords. You can do one job only for your constituents, and that's why I support the amendments, and I'm delighted that this chamber will be supporting them as well. Thank you, Presiding Officer.
I call Keith Brown.
Thank you, Presiding Officer. I'll be very brief as well. First of all, I welcome Graham Smith's voice in this campaign against dual mandates and will support all three of his amendments. I'm not sure why his voice has not been heard before now. It's just been a fairly recent thing that I've heard Graham Simpson talk about dual mandates and the evils therein. I'm not sure what could have prevented him from speaking up before. In any event, I think the point is, and I won't mention any names because I think it is wrong to concentrate on individuals in this. It should be we're making law because it's the best for everybody. In particular, it's the best for the electorate and the people of Scotland, and I think we have to bear that in mind. I think, though, the reason why I believe it's better to have it at the point of nomination, I mean, Edward Mountain just said that he supported the idea it was on election to a parliament, although then railed against the cost of needless council by-elections, which on average cost around £70,000. And sometimes you see people standing down immediately afterwards because they were disqualified in terms of being council candidates. However, in this case, in this Parliament, we would face, depending on what the regulations are, a very rapid by-election after a general set of elections caused by the election of somebody who is a member of the House of Commons, of the House of Lords. That would be substantially more than £70,000. But more important than that, I think if I just finish this point first and I'll take the member, it's also, I think, treating the electorate with contempt. I think we do not want to continue to alienate and disengage with the electorate. And the idea of having a by-election after a general set of elections within a space of a few weeks, when the electorate has gone through all the arguments at that general set of elections, surely the time to have that by-election would be during the set of general elections. I'll give way to Edward Mountain.
Edward Mountain.
I think the point that I'm not clear about is that when it comes to the council elections, I think it's been agreed that there will be consultation carried out by the Scottish Government to find out what's appropriate. Would the member accept that by carrying out the consultation it will probably drive the best answer rather than you and I, or the member and I, arguing about on council elections when somebody should step down?
Brown.
I agree with the member. I'll be very interested to see what the results of the consultation are. But the last point I would make is that whatever we agree in this Parliament, individual parties in this Parliament can take action themselves. So my party in 2020 decided we would have no dual mandates. There would be nobody that was an MP who would be standing for election to this Parliament, and we did that ahead of this legislation. So, unlike Graham Simpson, we've been against dual mandates for quite some time. But it will remain the case, whatever legislation is passed in this place, individual parties, if I just finish this point, I'll come to Mr Kerr, individual parties will be able to make rules for themselves. People can only stand for a political party, as we all know, if you have the mark of that party at the point of nomination, and that's the way that parties can exert their influence. I'll give way to Stephen Kerr.
It's really a point of information I seek from Keith Brown, because he's described a situation that existed in 2020 when Joanna Cherry famously was denied the opportunity to stand for this place. But what is the current position of the SNP in relation to Stephen Flynn, for example?
Well, Keith Brown. Joanna Cherry was not denied the opportunity. Another MP stood down, stood for election to this Parliament, won that election, and is now a Cabinet member in this Parliament. That is the way to do things, I believe. And the member asked about the current situation in the SNP. Well, we passed that measure for that set of elections in 2021. We will look at that measure again, of course, for 2026. All I'm pointing out is that every party in this chamber is able to do the same thing. And I would just plead that we do not take the electorate for granted. We know what the turnouts are like in local by-elections right now. I think one in Glasgow, the actual turnout in the day was around 6%, not including postal votes. We've got to start listening to the fact the electorate are turning away from elections, and having needless or pointless elections where interest is waned because we've just had a general set of elections is not the way to do that. So let's wait and see what the consultation says, but let's also be aware parties can take their own action in this area.
Thank you, and I call the Minister.
Thank you, Presiding Officer. Let me start by thanking all those who have engaged on this bill. The three members with amendments in this group have sought to be collegiate on these issues, and others in the bill, I hope they have felt the same of me, and we have been able to discuss views and in some cases come to agreement. This shows that advanced dialogue and discussion can be constructive throughout the passage of all legislation. I have appreciated the fact that we've had the opportunity to have had a thorough and full debate on this group of amendments. These are important issues, and it's good that we've done so. For those who are concerned that today's Stage 3 proceedings will be particularly lengthy based on the debate on this group, I suspect that despite it being the first group we are considering, it will probably be the one which takes us the longest. Let me begin with the amendments from Graeme Simpson in relation to dual mandates. On Saturday just past, the National Executive Committee of my party took a decision to put in place, as part of its selection rules, a prohibition on anyone seeking to hold elected office to this place to be able to do so while simultaneously remaining elected to the House of Commons. That was the position it took at the 2021 election. It's one it's taken for the forthcoming election. I support that position. I very much agree with Alec Cole-Hamilton about the privilege of being elected to this place, although I'm a little concerned that some of his sleeping hours are preoccupied with thoughts of working on in that regard. I hope he gets a little rest and relaxation over the Christmas period. However, the position my party has taken, and I think this speaks to the point that Keith Brown has just made, is a reminder that under the current law as stands, any party has always been able to determine for itself its own position on the issue of dual mandates for MSPs. At Stage 2 of this bill, as Graeme Simpson has mentioned, he brought forward a range of amendments to place in primary legislation a legal prohibition on the holding of dual mandates in relation to MPs, peers and councillors. Ross Greer brought forward another specifically focused on peers. I was clear with both them and the Standards Committee that, while I strongly believe there is merit in addressing the issue, including a full prohibition in the bill when no consultation or evidence gathering had occurred, and whilst indeed it was discussed at Stage 1, I would respectfully say not in great detail, this was not the appropriate manner in which to legislate for such provisions. I was grateful to both Mr Simpson and Mr Greer for not moving their amendments at Stage 2, given the nature of my concerns. At Stage 2, what I did commit to doing is to carrying out a public consultation in 2025, so an informed decision on the details of how we could prohibit dual mandates could be reached. I was clear with the committee, though, that in making such a commitment to a consultation, any changes arising out of it would realistically not be put into place until after the 2031 election, given the time required for the process of primary legislation. I was grateful then that Graeme Simpson came upon a solution that would enable me to satisfy my genuine concern about the need for consultation and engagement before prohibiting dual mandates, but still enable us to meet his ambition to do so in time for the 2026 election. Of course.
Martin Whitfield.
I'm very grateful to the Minister for taking an intervention. And on the question of the consultation that's going to be forthcoming, that consultation is very wide over the overlap of time, the process and identification. And my understanding is, and I hope the Minister can confirm this, that the Government is very open to listening to all sides in respect of that consultation to come up with regulations that will match, hopefully, if this has passed, the requirements in these amendments.
Minister.
Well, Mr Whitfield speaks to the very point of why I believe that consultation is important, because there are different perspectives on this matter. There might be broad agreement on the principle, but it isn't just a principle we're agreeing when we're passing legislation. We're making the law. And in making the law, it is incumbent on each of us in discharging the privilege we have when elected here to ensure that that law is as good as it possibly can be. So I was very pleased that I was able to engage with Mr Simpson, to be able to engage constructively to bring forward this proposal for Parliament to consider today. As Graeme Simpson has outlined, Amendments 34 and 35 would require ministers to lay regulations before Parliament to prohibit MSPs from also being able to simultaneously serve as either an MP or a peer. It should, and this will hopefully satisfy Mr Kerr's inquiry, should Parliament agree these amendments and then pass this bill, I am committed to ensuring that this is done by autumn 2025 to ensure regulations informed by the consultation, which I have committed to publish, are in place well ahead and effective by the Scottish Parliament election scheduled for May 2026. Amendment 36 includes similar delegated powers in relation to dual mandates for councillors, but unlike Amendments 34 and 35, those powers are discretionary. This in part acknowledges the distinct nature of councillor roles. And candidly, though, it also reflects what I detect to be a broader range of opinion in this chamber on that matter. And it, of course, allows the public consultation to guide us towards whether action is required or indeed whether it is not. I will report back to Parliament after the consultation is concluded and give an indication of the next steps thereafter, of course.
Douglas Lumsden.
An intervention. On 36, do you think there could be another way forward where maybe instead of someone being an MSP and a councillor, that they may only be able to take one salary, for example? I know a lot of councillors who become MSPs give up their councillor salary, but they don't have to. Do you think there could be a way of forcing them to do that?
Minister.
I think quite possibly there could. I don't know if that would be through the provisions as laid out in this bill. I suspect there might be other means by which we could consider that, and whether or not we determine that there should be strictly a legal prohibition on MSPs also being able to simultaneously be a councillor, that's something I'd be more than willing to consider in dialogue with any member who wants to explore it with me. In relation to the amendments, if it's not clear yet, President Officer, I encourage Parliament to support them, which I consider to be an appropriate conclusion to the deliberations we have had on the matter to ensure the issue of dual mandates can be considered properly and regulations informed fully, whilst ensuring the changes can still take place ahead of the 2026 election. And on Mr Simpson's indication that he has now laid his own bill before Parliament, can I first say this serves as a reminder that any one of our number can seek to bring forward legislation of the type we debate today, which seeks to look at issues of eligibility to hold elected office as a member of the Scottish Parliament. And in that regard, I'm sure I speak for us all when we look forward to Daniel Johnson's Members' Bill prohibiting dual mandates for MSPs and those elected to the Senedd, the Northern Ireland Assembly, or indeed the Greater London Assembly. Well, I'm sure it will be informed by the fact, and he will, of course, know this, that Section 16 of the Government of Wales Act 2006, amended in 2020, bars MSPs from membership of the Senedd. Mr Johnson says he was just testing me. I hope I've risen to the occasion. I do, though, more genuinely look forward to, with more imminence, to engaging with Mr Simpson on his forthcoming bill. President Officer, I will now turn to Annie Wells' amendments. I understand what she is trying to do. I think any person would recognise the disconcertion and concern a person might feel in the circumstances that she has described. That would be a very understandable human instinct. But as we discussed at stage 2, I believe there are insurmountable issues with these amendments, issues that Ms Wells is aware of as she withdrew other amendments at stage 2, acknowledging that those amendments did not meet Article 3 of Protocol 1 of the European Convention on Human Rights. And that remains the case. There are significant ECHR compliance concerns with these amendments, which I've outlined to Ms Wells in person and in correspondence. Amendment 3 engages Article 3 of Protocol 1, the right to stand for election to the legislature, and both amendments concern Article 8, the right to respect for private and family life. Neither amendment would, I recognise, bar a person from office, but both would have the effect of publicising an expired restriction or order. This would be the case no matter how much time had elapsed since the restriction or order was in place. It's the Government's view that these amendments, no matter how well-intentioned and no matter how much sympathy there might be in relation to the point Ms Wells is driving at, are incompatible with the Convention and, as such, out with the competence of the Scottish Parliament. President Officer, an amendment that's passed which is incompatible with the Convention and out with competence is not law, and of course I don't need to remind members of the concerns that would exist in risking this bill as a consequence. I'm sure Ms Wells' intention is not to risk this bill, and I'm sure she will also recognise that I am keen to avoid such an eventuality. In addition, it is also unclear how Amendments 3 and 37 would interact with the detailed law on spent convictions, which is contained in the Rehabilitation of Offenders Act 1974. What I can say, though, and I think it is important to place this on the record because I understand the nature of the concerns, is that there are improved safeguards already embedded in this bill that we debate today as a consequence of amendments that were brought forward at stage 2 that the convener of the committee, Mr Whitfield, has already mentioned. This bill, if passed today, will see a substantial change in relation to ensuring that anyone subject to a relevant notification requirement or sexual harm or risk order will be prevented from being an MSP or a councillor. I believe that provides a change in legislation and hopefully some reassurance in strengthening safety and in terms of public perception. Amendments 3 and 37 go a little too far in terms of compliance, though, and I'm grateful to Ms Wells for indicating she's not moving those amendments today. Finally, Presiding Officer, Ross Greer's amendments in this group cover disqualification orders under the Bill and the Elections Act 2022. These orders seek to bar people from office when convicted of a crime involving hostility towards elected representatives, campaigners and electoral workers. I have a great deal of sympathy with Mr Greer's suggestion that any offence involving abuse in an electoral context should also carry a sentencing aggravation. The Electoral Commission's report on the last UK Parliament general election spelled out the concerning increase in unacceptable abuse facing candidates and campaigners. It's also the case that we already provide additional protection for certain groups, such as emergency workers, by setting out statutory sentencing aggravations. At stage 2, Mr Greer brought forward similar amendments. At that stage, I was not fully persuaded of their merit, but having reflected further on them, and my officials having engaged with a range of relevant stakeholders who have not raised concerns at the proposition, I'm happy to say that the Government supports Mr Greer's amendments in this group, and I would urge Parliament to vote for them.
Thank you. Members will note that we are approaching the first time limit and we have a further group still to debate, and as a consequence, under Rule 9.8.5a, I'm minded to accept a motion without notice to propose that the time limit be extended by 30 minutes, and I would ask the Minister for Parliamentary Business to move such a motion.
On the basis of a commitment to try and make up some of that time, Presiding Officer, I move.
Thank you, Minister. The question is that the time limit for debate on amendments be extended by 30 minutes. Are we all agreed? Yes. We are agreed, and I call on Graham Simpson to wind up and press or withdraw Amendment 34.
Well, I will press my amendments and I will wind up simply by thanking everyone who's taken part in what has been a very good debate, and that includes my good friend Keith Brown, who made some very interesting point, which I respectfully disagree with, but it's right that he made it, and these kinds of issues can be looked at when we do the consultation. I would just urge the Minister, and I'm sure he'll do this, to be as collegiate as he has been so far when he looks at the regulations. I'm sure that will be the case, and on that I will sit down.
Thank you, Mr Simpson. The question is that Amendment 34 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 35 in the name of Graham Simpson, already debated with Amendment 34. Graham Simpson, to move or not move?
Moved.
The question is that Amendment 35 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 36 in the name of Graham Simpson, already debated with Amendment 34. Graham Simpson, to move or not move?
As moved.
Thank you. The question is that Amendment 36 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 3 in the name of Annie Wells, already debated with Amendment 34. Annie Wells, to move or not move?
Not moved, Presiding Officer.
Thank you, Ms Wells. The amendment is not moved. I call Amendment 37 in the name of Annie Wells, already debated with Amendment 34. Annie Wells, to move or not move?
Not moved, Presiding Officer.
Thank you, Ms Wells. I call Amendment 5 in the name of Ross Greer, already debated with Amendment 34. Ross Greer, to move or not move?
Moved.
The question is that Amendment 5 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 6 in the name of Ross Greer, already debated with Amendment 34. Ross Greer, to move or not move?
Moved.
Thank you. And the question is that Amendment 6 be agreed to. Are we all agreed? Yes. We are agreed. We move then on to Group 2, Joint Party Candidates, and I call Amendment 7 in the name of Daniel Johnson, grouped with Amendments 9 and 8. Daniel Johnson, to move Amendment 7 and speak to all amendments in the group.
Thank you very much, Presiding Officer. And it must be Christmas because everyone is praising one another for the full and engaged conversations that they've been having, and I am going to be no different. So can I thank the Minister for the conversations that we had last week, and also reiterate the apologies. My 3 amendments here do something that may not be entirely apparent at first glance, and quite rightfully should have been tabled at stage 2, and indeed I attempted to, and unfortunately the drafting was not right, and therefore I was not able to at this time. But they do something that's quite important. Now, there's much discussion in this place about people changing parties, whether they're a member of a party, and it may have escaped some people's notice that there are 11 of us in this chamber. They're actually a member of 2 parties, both the Scottish Labour Party and the Scottish Cooperative Party. Indeed, that is part of a tradition that is long-standing in our politics. The Cooperative Party was founded in 1917 and in 1927 formed an electoral alliance with the Labour Party, and ever since then has been standing joint candidates in elections at a UK level and a Scottish level. Now, I will stop my Labour Party history there. I am not entirely sure it was a way of winning votes, and I'm also very mindful with Richard Leonard at the back of the chamber. He might well correct me. But my point is this, is that political parties are an important part of our electoral system. And I think that the way that they work and interact with one another is also important. That I think much criticism, sometimes from outside this place, is about parties being insular. And therefore, the possibility of parties working in tandem with one another, in conjunction and cooperation, is a really important one. And indeed, I think that the relationship between the Labour Party and the Cooperative Party, which is fundamentally what these 3 amendments are about, and there's no point in dressing up in any other way, it is actually a useful one. So the 3 amendments are as such. The first amendment, Amendment 7, is about enabling candidates to give a joint description between 2 political parties, and importantly extending that towards local government elections. And the subsequent amendments are about the recognition of third parties, i.e. this is about recognising the cooperation that exists between 2 parties for the purposes of organisation and election expenses. Now, I recognise in particular those latter 2 amendments, I think, are perhaps complex, and I'm sure the Minister will arrive at that. And so I will bear that in mind as debate proceeds and the comments that he makes. But I think there is an important point of principle here. Each and every one of the parties actually represented in this chamber today has either been formed from relationships with other parties or has existing ones. The Conservative Party merged with the National Liberal Party after the Second World War. The Liberal Democrats are formed out of an alliance, which we may remember, between the Social Democratic Party and the Liberal Party. The SNP, of course, was formed out of a merger of the National Party for Scotland and the Scottish Party. And so, therefore, I think there is a precedent in each of our... And indeed, the Greens demerged from the UK Green Party in the 1980s and has a relationship with its other Green Party. In fact, it was alluded to earlier by Mr Greer, the relationship they have with their sister parties in other parts of the world. I.e., this is an important part of our democracy, and I think recognising the relationships that parties have with other parties is important. And I think it's also important for one other reason. The relationships that parties have with third parties can be exceptionally sensitive. None of us want to see our politics emulate that of the United States, where we have third-party organisations which apparently exist completely out with the organisations of individual parties and super PACs. Therefore, I think we need to proceed very carefully in this space. And I do have my concerns, and I voiced them to the Minister directly, about the ability for the Executive to designate organisations as being third parties, or indeed not being third parties. So I think there is a broader point of principle here, which, as we think about the way that our democracy works and the way elections this place work, I think we should give deeper consideration to. But on this point, I was about to draw my remarks to a close, but happy to give way.
Stephen Kerr.
Daniel Johnson...
Can we have Mr Kerr's microphone?
Daniel Johnson hasn't made it clear, and I think I'd like to ask him a very direct question. is the amendments 9 and 8 that are listed here an attempt to give the cooperative party third-party status that would allow the Labour Party then some financial advantage when it comes to the activities of the cooperative party? Because that is what it looks like and sounds like. I'd be very grateful he'd be absolutely clear. He mentioned they're technical, but I think the Chamber deserves to hear the ramifications of what these amendments say, particularly in relation to his own party and any possible advantage.
Daniel Johnson.
He's quite correct, and although I would actually say it's the opposite. But I think there is an important point of principle here about the recognition of activity. This actually is, in a sense, a disadvantage, because what it's saying is that the resources and activities of a third party should be included in the electoral returns of members who are standing as both Labour and Cooperative Party members. So it's actually to have a full account, and that there's no possibility of activity and, importantly, expenditure not being included in that activity. So it's actually about proper accounting of expenditure and activity that takes place where members are standing on behalf of two parties, not just a single party. I recognise this. No need to look. The member looks exceptionally worried. He needn't. I am actually trying to ensure that things are above board and proper. I doubt my amendments are going to go through, so I don't think you need to worry too much. But I think his concern, reflects a broader point, where I think this is an area where I think future consideration should be given. But this is about making sure that the activities of the Cooperative Party are fully acknowledged and accounted for when Labour Party and Cooperative Party candidates are standing for this place. And with that, I'll close. Thank you.
Thank you, Mr Johnson. I now call Sue Webber.
Thank you, Presiding Officer. Mr Johnson has almost answered the questions I have here on the Amendments 8 and 9, because he has spoken about historic alliances that have come about from various parties across this chamber, but the difference is that we are all sitting here now as only one party. And I still interpret Amendments 8 and 9 as giving the Labour Party and those that are Cooperative Party members an unfair advantage over others sitting in this chamber. And despite what he said to Mr Stephen Kerr there about a third-party expenditure being included and all of that about proper accounting, I still have concerns that make these amendments a challenge for me. Mr Johnson did call them useful amendments, but I'm also concerned that these may not be quite as useful for Parliament as they are for the members that sit with the Labour Party and Cooperative Party. Thank you, Presiding Officer.
Thank you. And I call the Minister.
Presiding Officer, as a student of history, if nothing else, I've enjoyed Mr Johnston's contribution to this group of amendments as such. Dan Johnson's amendments raise a number of complex points which have not been raised at any point during the course of the bill's passage, either at stage 1 or stage 2 by Daniel Johnson or anyone else. I recognise the point he made about some of the challenges he faced in terms of getting the amendments drafted for stage 2. And whilst I was grateful to him for the time he gave me to discuss the amendments last week, I'm afraid I cannot support them, and let me set out why. In the first instance, I acknowledge that Amendment 7 seeks to apply the existing position that we already have for Scottish Party elections to local elections. However, this is a change that can be achieved by existing secondary legislation powers. Indeed, the amendment itself clearly refers to existing secondary legislation. As a general rule, I do not think it's particularly good practice to amend secondary legislation via primary legislation, not least where any such changes could be otherwise made using the secondary legislation-making process. So I would therefore suggest that Mr Johnson does not press Amendment 7 today, and instead I discuss the matter further with him and the merits of this change featuring in the conduct order, which will be prepared ahead of the 2027 local government elections, as we permit consultation with interested parties such as the Electoral Commission. Amendments 8 and 9 are significantly more complex and delve into the rules set out in the UK-wide Political Parties Elections and Referendums Act 2000. I recognise that Mr Johnson said he was unable to lodge amendments in this area at stage 2 due to drafting issues. I'm afraid that I have some concerns about drafting here too. Mr Johnson explained to me his concern that changes made in the Elections Act 2022, that's a UK Act, have resulted in what, in his view, may be unintended consequences in this area. These are therefore areas that could have been discussed long before amendments were lodged at stage 3. On Mr Kerr's point, and let me take Daniel Johnson's response to him, that this does not seem to have been Mr Johnson's intent. Where there is a joint party candidate, the proposed amendments do seem to allow one or both of the registered parties to also be a registered third party, meaning they would therefore gain access to third-party campaign spending limits in addition to the normal party spending limits. The third party that is not eligible to become a recognised third party is subject to a £700 limit. That, to me, Presiding Officer, notwithstanding long-standing arrangements between the Labour Party and the Cooperative Party, does not seem fair as a point of principle. Why should registered parties fielding a joint candidate at a Scottish Parliament election be permitted to incur significantly more expenditure than a candidate standing for the more normal route of one party? I'm also concerned that such a change could open the door to possible abuse of the system of regulation on spending by a host of phantom joint candidacies. Indeed, we have been in discussion with the Electoral Commission, who have highlighted the risk that the proposed amendment may create an uneven playing field among parties contesting a Scottish Parliament election by permitting parties involved in fielding joint candidates access to additional spending over and above the limit set out in Schedule 9 of the Political Parties Elections and Referendums Act 2000. In addition, the complexity of the rules on campaign finance also mean, and this really speaks to the real fundamental concern, Presiding Officer, they mean that Mr Johnson's Amendments 8 and 9 are out with legislative competence. While the Scottish Parliament can make changes to the Political Parties Elections and Referendums Act 2000 in respect of Scottish Parliament elections, there is a reservation in Schedule 5 of the Scotland Act 1998 which applies if a Scottish Parliament election is held in the 12 months prior to a UK general election. We cannot make changes to the rules in Parts 5 and 6 of the Political Parties Elections and Referendums Act 2000 in that situation. Because Amendments 8 and 9 do not take that point into account, they could impact upon a Scottish Parliament election held in such a timeframe. This means that the Government considers both Amendments 8 and 9 to be out with the competence of the Scottish Parliament, and indeed I have highlighted that point directly to Mr Johnson. As I said earlier in relation to the last group, an amendment that is passed which is out with competence is not law. Section 33 of the Scotland Act allows law officers to refer a bill to the Supreme Court for determination of whether it is within the legislative competence of the Parliament. That would happen before the bill gets royal assent. Therefore, agreeing Amendments 8 and 9 could jeopardise the whole bill. As Mr Johnson and other members would imagine, just as with Annie Wells' amendments in the previous group, which he did not move, I cannot agree to something that would imperil the bill. I would therefore urge Mr Johnson not to press his amendments today, but if he does, I would urge all members to vote against them.
Thank you, and I call on Daniel Johnson to wind up press to withdraw Amendment 7. Mr Johnson.
First of all, let me just be very clear. My intent was really about having full recognition and proper accounting for joint status. Certainly, I wouldn't want anyone to think that anything that I was bringing forward was anything other than that, and other than essentially recognition of the long-standing relationship that the Cooperative Party has had with the Labour Party. On the points themselves, I quite agree that given that this arose out of the 2022 Elections Act, there was time. I was somewhat at the mercy or a full victim of people bringing this late in the stage to me. I was simply, but I take the Minister's point. But most importantly, given the undertaking has to look at the descriptions and bring that forward through secondary legislation, I will withdraw Amendment 7, and I fully acknowledge the issues set out by Amendments 8 and 9, and I will not press those either.
Thank you, Mr Johnson. Daniel Johnson seeks to withdraw Amendment 7. Does any member object? No member objects. Therefore, Amendment 7 is withdrawn. I call Amendment 9 in the name of Daniel Johnson, already debated with Amendment 7. Daniel Johnson to move or not move?
Not moved.
That is not moved. I call Amendment 8 in the name of Daniel Johnson, already debated with Amendment 7. Daniel Johnson to move or not move?
Not moved.
That is not moved. We move to the next group on ballot papers. I call Amendment 10 in the name of Ross Greer. In a group on its own, Ross Greer to move and speak to Amendment 10. Mr Greer.
Thank you, Presiding Officer. In moving Amendment 10, I want to thank Kenneth Gibson for his support and the Minister and the Bill team for their support with this. This is a simple amendment to require a review of how candidates and parties are ordered on the ballot paper. Members will be familiar with the question of ballot randomisation as a result of the pretty strong evidence of advantage for candidates who are at the top of the ballot paper. And with the way that we, like a lot of other countries, order our ballot papers, that means candidates whose names appear at the top of the alphabet, some of whom are staring me down in the chamber as I say this. But there is quite comprehensive evidence on this issue. There's a very thorough study from Denmark's 2015 municipal elections that shows an average advantage of 4% in vote share for the candidates at the top of the ballot paper. We've not had the same kind of rigorous study here in Scotland. I think that would be useful, but there's plenty of others worldwide showing a similar effect. This is about the principle of fairness, but also the perception of fairness, which I think we can all acknowledge is almost as important as the principle of fairness in and of itself. Elections need to look fair to have public confidence. So this amendment simply mandates a review with no specific outcome in mind. Various members have suggested either randomisation of ballot papers, having two different ballot papers, so half the ballots in a ward are printed A to Z, the other half Z to A. There's a range of different options. There are accessibility issues to consider there, I would certainly acknowledge. Ministers actually have the power to vary ballot paper order by regulation already. So this amendment simply requires that they undertake that review and consider what the options might be. And I brought this forward because this is a bill about strengthening our democracy, and I think in a small but significant way, this amendment, the review and its outcomes would do so.
Thank you, Mr Greer. I now call Kenneth Gibson.
Thank you, Presiding Officer. I wish to speak to Amendment 10, and I'd like to thank Ross Greer for bringing it to the Chamber. Over the years, I've raised the issue of how the alphabetic order of candidates impacts on election outcomes when two or more people from the same party contest the same council ward and single transferable vote on a number of occasions. I'm therefore delighted to speak to Ross Greer's amendment. I have to say that there has been some research. John Curtis did research on this, and more recently Kevin Boyle, who was a researcher who worked with Michael Shanks, among others. The impact of one's surname in STV elections is undeniable. It's been present at every single local authority election since the introduction of STV. In the 2022 election, in wards where parties stood two candidates, those with their surnames higher up the ballot paper received more first preference votes than their lower placed colleagues, an astonishing 83% of the time. In previous STV elections, the figure has been between 80 and 85%. On the rare occasions where a party fielded three candidates, the poor soul, lowest down the ballot, tops the poll amongst party colleagues a mere 1% of the time. When a lower-ranked candidate has prevailed over a higher-ranked colleague, most of the time it is only through incumbency. The effect is so widely known that parties spend time, money and effort developing strategies to work round it, generally focused on encouraging more supporters to vote for the candidate whose surname is lower on the ballot in most of the ward to offset the advantage the higher-ranked candidate has. This is known as the ward management strategy, as every person in this chamber knows. Female candidates have been known to use their maiden name or married name based on alphabetical order. It can skew selection contests too. A candidate named Gibson is more likely to want William Wallace as a running mate than Alistair Allen. I even know of a councillor who recently changed their surname to start with an A. I would, Mr Allen.
The member will, however, concede that his theory has not been put to the test recently, as I have not recently stood on the list.
Kenneth Gibson.
Well, indeed. I even know of a councillor who recently changed their surname to start with an A, as I've just said. The only dissenting voice against the reality of this effect is an Electoral Commission study from 2019, which fundamentally misunderstood the problem. Their hopelessly flawed study asked research participants to find and vote for a specific fictitious candidate on the ballot paper. This ignores the fact that many people have a preferred party rather than a preferred candidate, and the problem is primarily about the distribution of votes within parties. Presiding Officer, a number of attributes that should be used to judge candidates on: integrity, competence, accountability and work ethic, to name but a few. Instead, a candidate's surname is their primary advantage or disadvantage against their party colleagues, and this is fundamentally unfair and undemocratic. The Scottish Government previously said this is not a bigger problem as many people make out, and that it's down to those involved in the political process to ensure the public are aware of how the system works. 2 points on that. Firstly, those higher up the ballot paper beat their party colleagues 80 to 85% of the time. And if that figure isn't high enough to be a problem, what is 90%, 95%, 100%? Secondly, we've had 18 years of parties supposedly educating the public about STV. What has it been said or tried that has not already been said or tried? And if the case was as the Scottish Government has previously stated, why does the Scottish National Party, as well as other parties, have a vote management strategy in council wards, including, I suspect, in the Minister's own Cumbernauld constituency? Now, the SNP itself adopted randomisation of ballots for internal elections donkeys years ago. So why did we do that if not to tackle a real issue, even amongst party members? At some point, we need to face up to the reality of the system as voters interact with it, and not how we wish they did. Randomisation would nullify the alphabet, ensuring election outcomes are fairer and more democratic, reflect voters' genuine preference rather than just the ballot layout ending this ludicrous built-in bias. Now, I feel some responsibility for this because when I moved in 1995 at the SNP conference, STV should be our method of election in local authority and other elections. I didn't realise that parties would be too cowardly to put up more than one candidate, often in many wards, two at most, because they always play safe first rather than give voters a real choice, and also that this would be such an issue, but it is, and we must address it. This amendment, of course, only calls for a review, as Scottish ministers are reluctant for reasons I've never quite fathomed, but I hope that Mr Hepburn will tell us today to change the system now. Robson's rotation, a simplified version of which is used in Tasmania, is indeed the gold standard. Thanks again to Kevin Boyle for his research, John Curtis for his research, most of all to Ross Greer for bringing this amendment. I do worry, in fact, that if this is not actually addressed, the systematic bias inherent in the customs system will drag on with the force of inertia, and the current system may prevail in the next local council elections in 2027. I hope not. In the meantime, let's make a start and urge members to support Amendment 10 in the name of Ross Greer. Thank you.
Thank you, Mr Gibson. I suspect the next two speakers will have some sympathy with the plight of William Wallace. I call first Sue Webber, to be followed by Martin Whitfield.
Thank you very much, and I stand today to speak to Amendment 10 in the name of Mr Greer, and I welcome the fact that Ross has reintroduced this amendment, importantly this time with the requirement for a consultation first. Having a surname beginning with a W, I wholeheartedly agree with what Mr Gibson has just outlined and understand the arguments for randomised balloting. When I first stood as a candidate in Pentland Hills Ward for the Council, I was one of two candidates. The other candidate for the Conservative Party had a surname beginning with a B, and I was beginning with a W. But if I found out after the election, if I actually went far enough back in my family tree, I could have called myself Anderson. But there you go. But I am glad that what we're looking at today is, I'm really concerned that we do this with some robust consultation. Because one of the first things I received from Minister Hepburn when I rejoined the SPPA committee in October was a letter addressing issues with accessibility and issues during elections in terms of that. It was a pack that contained a trial tactile voting device. So I have real, genuine concerns about how randomisation would work alongside something like this. Indeed, how a voter with a visual impairment would prepare themselves to vote with no knowledge as to the order candidates may or may not appear on a ballot paper. And the same conclusions may be just as relevant for voters with other impairments and disabilities. This does make things more complex and confusing and unfamiliar as they cast their votes. And I do understand all the evidence that Mr Gibson has outlined today, but the unintended consequences from our desire to make things equal for those with surnames beginning with W does deserve a much more detailed consultation and scrutiny. I thank you, Presiding Officer.
Thank you, and I call Martin Whitfield.
I'm very grateful, Deputy Presiding Officer. And as the final W in this debate, following Sue Webber, precursed obviously by Ross Greer and indeed Kenneth Gibson, I want to talk in support of this motion because of all of the items that came up, both objectively and to a certain extent, or more so subjectively, amongst members across this chamber. It was the question of the order of candidates on ballot papers. It is a heart-lived and close challenge, particularly for those who have been unsuccessful. But I think it is right to echo Kenneth Gibson's submission that there is evidence to show, there is very strong evidence to show, that where you appear on the ballot paper plays some way into what the results of the election are. There are accessibility issues, and Sue Webber was right to point out that the government on a number of occasions have rightly pointed out the challenge of this. But it is not insurmountable, and can I thank Ross Greer for the phrasing of this amendment, because it's requiring a review. And I think in requiring a review, we can actually probably get, if not quite to the solution, maybe to put to bed some of the views that people have that are incorrectly held, but more importantly, to find out what the actual experiences are among those with accessibility issues, but also about the effect of the alphabetisation of the ballot papers in this matter. At that point, I rest. I'm grateful.
Thank you. I now call the Minister.
Thank you, President Officer. Let me begin by offering Ross Greer reassurance that with a surname firmly planted in the middle of the alphabet, I do not intend to stare him down as I address my remarks. And can I say to Mr Gibson, I think it's important that I make this point, President Officer. I represent the Cumbernauld and Colsouth constituency. My Colsouth constituents get very upset, rightly upset, when they are forgotten. But it is right to say that in my constituency we operate a voter management strategy, and that allows me to place on record the result in the Cumbernauld North Ward, where Councillor Alan Masterton got 30.5% of the vote, by contrast to Councillor Danish Ashraf's 19.7% of the vote. It can be done. Nonetheless, it is clear that many members have concerns that using alphabetical order to list names on ballot papers can have an unfair impact. This is an issue that many have raised over some period of time, almost exclusively in respect of local government elections. At stage 2, we had, I think, a very healthy discussion about the merits of randomisation as an alternative approach. This has been raised as an option by the government in its consultation on electoral reform 2017. I hear Kenny Gibson's point that no one has raised concerns other than the Electoral Commission about randomisation. I did highlight at stage 2 the evidence received from disabled people's organisations at that point in 2017, when we undertook our consultation, that a switch to randomisation might have an adverse impact on voters with accessibility needs. Notwithstanding the genuine and sincere concerns that members have expressed about the impact of alphabetical listing of candidate names in any ballot paper, concerns I recognise and understand, so too must we hear the equally genuine and sincere concerns of those disabled people's organisations as we consider the way forward. At stage 2, I was keen, I stressed that I was keen to engage with Ross Greer on a possible way forward, and I'm pleased to be able to work together on Amendment 10. I very much hope that the study it requires the government to take forward, should we pass this amendment and pass the bill, will result in a full and proper consideration of this issue. The study is designed to any change, should one be identified as being necessary, could it be made in time for the 2032 local government elections. That seems to me to be the most appropriate, as the local government STV system attracts the most comments about the impact of the alphabetical list order. On that basis, I encourage members to support this amendment.
Thank you. And I call on Ross Greer to wind up press or withdraw Amendment 10. Mr Greer.
Thank you, President Officer. About pressing Amendment 10. In closing, I just want to thank Kevin Boyle and John Curtis for the research work that they did on this, and to echo Kenneth Gibson's frustrations about the Electoral Commission's 2019 study, which was an opportunity to do something in Scotland as thorough as the Denmark 2015 study that I mentioned and various others internationally, but sadly was a missed opportunity to do so. I'm glad that Sue Webber covered the issues of accessibility, because what we're trying to do here is balance not mutually exclusive inclusive outcomes, but outcomes for which there is an element of tension, and therefore the review, I think, is the right way forward. As the Minister highlighted, Scotland's use of STV, a perfectly good system for our local elections, does appear to increase the challenges created by alphabetical order of ballot papers, and I think it is incumbent on us, therefore, to look at this primarily with a focus on the local elections. And I'll just finish off by saying, to the Minister's example of Cumbernauld North and the councillors Masterton and Ashraf, I would suggest that Councillor Masterton's years of excellent service as an incumbent councillor in that ward probably did him no harm whatsoever. Yes.
Minister.
I think we should let the record show Councillor Ashraf was also an incumbent.
Ross Greer.
I would, of course, recognise both councillors' incumbency. Having known Councillor Ashraf before, I should definitely put that on the record, but having known Councillor Masterton for much longer, I would suggest that his incumbency certainly helped in that. And it does go back to the point that Kenneth Gibson made of the evidence of the order of party candidates when parties are fielding more than one candidate, and the fact that you can clearly match up where candidates are or are not incumbents based on the relative vote share that they get across a party's candidates. So the evidence base is clear. It appears there's clear consensus across the Chamber for that. So I would just finish by, again, thanking the Minister and the Bill team for their work on this particular amendment.
Thank you, Mr Greer. The question is that Amendment 10 be agreed to. Are we all agreed? Yes. Parliament is agreed. We move to Group 4, minor and technical. I call Amendment 11 in the name of the Minister, grouped with Amendments 12, 13, 14, 15 and 16. Minister to move Amendment 11 and speak to all amendments in the group. Minister.
Thank you, President Officer. These amendments are, as the technical suggests, extremely minor. They only tidy up issues and do not make changes to any policy. They concern non-government amendments proposed by Ross Greer, but which I supported at stage 2, adding sections 27A and 27B to the bill. One change allowed candidates at local government elections to choose to display their ward of residence in the ballot paper. The other permitted election agents to request that their publicly available address be a correspondence address rather than their home address. They were already being considered as changes by the Scottish Government as part of a package of regulations we will take forward next year, but I was happy to see them added to the face of this bill at stage 2. Amendments 11 and 12 insert the SSI references into sections 27A and 27B to reflect best drafting practice. There is no policy implications to these amendments. Amendments 13 to 16 make changes to section 27B of the bill, replacing the word regulation with article throughout the section. These amendments reflect that the second legislation measures being amended are orders rather than regulations. I move Amendment 11, President Officer.
Thank you, Minister. No other members have asked to speak. Is there anything you wish to add by way of wind-up, Minister?
No, President Officer.
The question is that Amendment 11 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendments 12, 13, 14, 15 and 16, all in the name of the Minister, all previously debated. I invite the Minister to move the amendments en bloc. Minister.
Move, President Officer.
Does any member object to a single question being put on Amendments 12 to 16? No member objects. Therefore, the question is that Amendments 12 to 16 be agreed to. Are we all agreed? Yes. Parliament is agreed. We move to Group 5, pilots electronic voting. I call Amendment 17 in the name of Ross Greer, in a group on its own. Ross Greer to move and speak to Amendment 17. Mr Greer.
Thank you, President Officer. I move Amendment 17. I think this is a very welcome section of the bill, empowering the use of pilots to boost democratic engagement. But of course, there's always a risk when we're changing the arrangements for something as fundamental as how we vote, how we elect those who govern either locally or nationally. Electronic voting is an issue that's been debated before in this Parliament, but I think only in members' debates and in a couple of committee sessions. Many of us are concerned about electronic voting for a range of reasons. Any voting system has to be both secure, anonymous and verifiable. Electronic voting can only guarantee 2 of those 3 outcomes. There's an element of mutual exclusivity when you're trying to resolve all 3 through an electronic system. So my amendment here is not seeking to ban electronic voting. I think that is a much wider debate. What I'm trying to do is require that debate to take place before even a pilot using electronic voting is to proceed. It's simply putting a check onto the system. So if a pilot proposal is made for the use of electronic voting, given the unique concerns that exist around it and the fact that any pilot would still be for a real election, this would require that to come before Parliament and to seek parliamentary approval, giving an opportunity for effective scrutiny. So Amendment 17 is quite simple. It requires that any electronic voting pilots are approved by Parliament through a statutory instrument before they are brought into place.
Thank you, Mr Greer. I now call the Minister.
Thank you, President Officer. I appreciate the point of principle raised by Ross Greer that any pilot on electronic voting would represent a significant development. I recognise that there are security concerns potentially around any move to voting electronically. There are many bad actors who might relish an opportunity to seek to disrupt or adversely influence democratically elections. I can certainly reassure you, President Officer, Mr Greer and other members that the Government has no plans for electronic voting other than possible changes targeted on the needs of voters with accessibility requirements. At stage 2, Mr Greer brought forward an amendment that would have potentially captured a much broader range of initiatives that might be piloted, even where they might be relatively minor innovations. Mr Greer was clear that his concern was specifically related to electronic voting, and I am pleased to have subsequently worked with him on this amendment, Amendment 17, which will ensure Parliamentary approval is given for any electoral innovation pilot that involves electronic voting. I am therefore happy to support this amendment.
Thank you. I call on Ross Greer to wind up, press or withdraw Amendment 17. Mr Greer.
Nothing further to add. I'll be pressing Amendment 17. Thank you.
Thank you. The question is Amendment 17 be agreed to. Are we all agreed? Yes. Parliament is agreed. We move to Group 6, boundaries. I call Amendment 18 in the name of Ross Greer, grouped with Amendments 19 and 20. Ross Greer to move Amendment 18 and speak to the other amendments in the group. Mr Greer.
Thank you, Presiding Officer. I'm almost done. Members will be glad to hear. This continues on some work that I began at stage 2, and again I'd like to thank the Minister and the Bill team for their cooperation with this. And ultimately, at its core, it's a simple proposal that any boundary reviews be conducted at least 18 months before an election, recognising the fact that the public, but primarily political parties and candidates, need time to prepare. Parties need time to select candidates for the relevant electoral boundaries in particular. So Amendment 18 clarifies that the amendment agreed at stage 2 applies to local elections, so it's simply about clarifying rather than a substantive change. Amendment 19 brings the overall review cycle into sync, given the changes that have already been agreed, and Amendment 20 applies that 18-month limit to any change of boundaries to elections to this Parliament as well.
Thank you, and I call the Minister.
President Officer, I am pleased to be able to discuss and work with Ross Greer on these amendments. Having an 18-month period before elections where the electoral boundaries are confirmed is a sensible change. Indeed, they were changes that I was already interested in pursuing before Mr Greer brought forward his amendments on this area at stage 2. As we discussed at that stage, whilst I supported the intention behind his amendments, I couldn't support them as they had what I recognised was an unintentional change to the timeframe for reviewing boundaries for the 2027 local government election. Realistically, such a change to the timeframe by which Boundaries Scotland has to finalise its proposals for ward boundaries can only be applied for the 2032 local government election and beyond. These amendments, which I've been pleased to work with Ross Greer in framing, achieve that and will give greater certainty to constituents, administrators and candidates for both local government and parliamentary elections. With his having brought a proposition to establish an 18-month lead-in period for local government ward boundary changes, I also took the view that the same would be sensible for constituency and regional boundary proposals for parliamentary election. I'm grateful that Mr Greer also brought forward an amendment to achieve that. President Officer, it also seems to me to be helpful to update Parliament that have written to the standards of local government committees outlining plans to establish an independent review to consider boundaries legislation and processes that will be tasked with making recommendations for how a system of automatic approval of electoral boundary changes could work in Scotland, something the Standards Committee has taken a great interest in. The review will take account of experience elsewhere in the UK and international best practice and report next year so the Parliament can consider its recommendations. But meantime, I would ask members to support Ross Greer's amendments in this group.
Thank you. I call Ross Greer to wind up, press or withdraw Amendment 18. Mr Greer.
Grateful to the Minister's support. Nothing further to add, so I'll be pressing Amendment 18. Thank you.
Thank you. The question is Amendment 18 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 19 in the name of Ross Greer. Ready debate with Amendment 18. Ross Greer to move or not move?
Move. Thank you.
The question is that Amendment 19 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 20 in the name of Ross Greer. Already debated with Amendment 18. Ross Greer to move or not move?
Move.
Question is that Amendment 20 be agreed to. Are we all agreed? That is agreed. We move to Group 7, Electoral Management Board. I call Amendment 21 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 21 and speak to all the amendments in the group. Minister.
Thank you, President Officer. The amendments in this group, the final group of amendments, we have further modified the new constitution for the Electoral Management Board for Scotland, or EMB for short, that the bill introduces. Changes made at stage 2 will see the Scottish Parliamentary Corporate Body assuming oversight for the EMB. The amendments today are largely further technical refinements following discussion with the EMB and SPCB officials. Amendments 21 and 22 remove the word draft from the provisions requiring a strategic plan setting out the EMB's priorities over the next 5-year period to avoid any ambiguity over the status of the plan whilst it's being considered. Changes at stage 2 expanded the pool of potential board members for the EMB to include serving or former returning officers or electoral registration officers from England and Wales. Amendment 23 makes a small expansion by covering returning officers for local elections and acting returning officers from England and Wales. I must be clear that the bill will in no way require returning officers or electoral registration officers from other parts of the UK to be appointed as members of the EMB. Instead, the bill seeks to expand the possible pool of candidates, and also paragraph 2(5) of the new schedule setting out the EMB's constitution ensures that the membership as a whole still has Scottish experience. Amendment 24 makes clear that the convener holds office in such terms and conditions as the SPCB may determine. Similarly, Amendment 25 provides that the SPCB approval is needed for convener setting the terms and conditions for the other board members. Amendment 26 ensures that the appointment period of any deputy convener must be approved by the SPCB. Amendments 27, 28, 31 and 32 modify the rules on remuneration and pensions of the EMB convener and other board members and staff. These changes ensure consistency with other legislation where bodies report to the SPCB. Amendment 29 clarifies that where the board may obtain advice, assistance or any other service from qualified persons, any payment is subject to the approval of the SPCB. Amendment 30 allows the SPCB to issue directions to the EMB on the sharing of premises, staff, services or other resources with any other public body or any office holder. Amendment 33 removes provisions requiring the SPCB to indemnify the entire EMB. This is consistent with the bill making the EMB a corporate body. And in that regard, I would just like to finish by thanking the EMB and SPCB officials for their help with these changes. The EMB has been highly successful in supporting the smooth running of elections in Scotland, and the changes made by the bill will consolidate its independence and build upon its strengths. I move Amendment 21.
Thank you, and I call Martin Whitfield.
I'm very grateful, Deputy Presiding Officer. I really might rise to echo the thanks to the Electoral Management Board for their contribution throughout the course of this bill and their suggestions and recommendations. And indeed, Group 7 takes us in some ways further forward than any of the other areas in this election bill by removing from a voluntary nature of people with expertise in elections gathering together to assist us to one that has a corporate body that can actually enter contracts, can actually pay for the services and not rely on one returning officer's credit card or an ERO's credit card, although it's less complex than that. The journey from where the suggestion of a legal identity from the Electoral Management Board right at the start that came back through the consultation to where we are today again has been quite a challenging journey at times, but I would like to compliment the Minister and indeed the government officials for the lengths that they've gone to ensure that there is a recognition of the areas that were raised that would possibly be of concern and the relationship that the EMB will have with the corporate body of indeed this Parliament as in essence its overseer for the purposes of audit and finance. So I can confirm that we will be supporting all of the amendments in this group, but once again would like to take the opportunity to both thank the Electoral Management Board but also to thank returning officers and indeed electoral registration officers for their assistance in this. I'm grateful.
Thank you, Mr Whitfield. Minister, to wind up.
Just very briefly to concur and agree with Mr Whitfield in relation to his remarks on moving the status of the EMB from being a voluntary body to being a corporate entity. I do consider that to be a significant improvement in terms of governance and accountability, importantly to this Parliament and not to the Government. And also I very much appreciate his remarks in terms of the activity and the effort of Scottish Government officials, of Parliament officials and those involved in the EMB. They have all worked incredibly hard to get to this place, and I am also simply grateful for the efforts they've undertaken.
Thank you, Minister. The question is that Amendment 21 be agreed. Are we all agreed? Yes. Parliament is agreed. I call Amendments 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32 and 33, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 22 to 33 en bloc. Minister. Thank you. Does any member object to a single question being put on Amendments 22 to 33? No member objects. Therefore, the question is that Amendments 22 to 33 be agreed. Are we all agreed? Yes. That is agreed, and that ends Stage 3 consideration of amendments. As members will be aware, the presiding officer is required under standing orders to decide whether or not, in her view, any provision of a bill relates to a protected subject matter, that is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. In the case of this bill, in the presiding officer's view, no provision of the Scottish Elections Representation and Reform Bill relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at Stage 3. The next item of business is a debate on motion 15875 in the name of Jamie Hepburn on Scottish Elections Representation and Reform Bill at Stage 3. Members wishing to participate in the debate should press the request to speak buttons. And I call on Jamie Hepburn to speak to and move the motion. Minister, around 7 minutes, please.
Presiding Officer, this year we have been celebrating the 25th anniversary of the reconvening of the Scottish Parliament. Since the first election in 1999, this Parliament has improved participation, it's extended voting rights and it's enabled more people to stand for election. The Scottish Elections Representation and Reform Bill seeks to continue the evolution of our elections. This is a wide-ranging bill containing a mix of technical improvements and substantial advancements. It's the result of extensive consultation both before and after introduction. I am pleased we have an improved bill following the engagement of members and would like to express my thanks to all those who have contributed, many of whom have spoken in the amendment stage today. I'd like to thank past and present members of the Standards, Procedures and Public Appointments Committee, the convener and their clerks for their engagement throughout the bill's progress. I would like to put on record my appreciation for the hard work of the bill team on this legislation. I also want to pay tribute to my predecessor, George Adam, who is recuperating in his sickbed because he's got COVID-19 right now. Otherwise, I know he would have been here as an officer, who made it very clear at the introduction that it was to be considered Parliament's bill. And I hope members will agree that we have all upheld that spirit. The bill seeks to improve candidacy rules across the board. It empowers foreign nationals who have made their lives here to stand for election. And it means people committing offences in an electoral context can be disqualified from office. Being involved in an election is, I think we all recognise, a challenging undertaking. The Electoral Commission's recent report on this year's UK Parliament election highlighted the aggravation and intimidation that those standing for election can face. It's partly because of those concerns that the initial proposal to expand candidacy rights to 16 and 17-year-olds was ultimately not included in the bill. We also know that there are also barriers to standing for election. That's why this government introduced the Access to Elected Office Fund, which has supported over 120 disabled candidates of all parties during 3 national elections since it started in 2017. So I was very pleased to be able to work with and support Jeremy Balfour's amendment that will put that fund into statute. Presiding Officer, this bill also makes a significant change in disqualifying anyone who commits a sexual offence from elected office. Banning people subject to sexual offence notification requirements and risk orders from elected office will, I believe, help reassure the public that they can trust their elected representatives. The Government has played its part in those changes, but they also are the fruit of cross-party engagement, particularly with the Standards Committee, who engaged with this complex issue sensitively and diligently. Presiding Officer, many other topics are addressed in this bill. I thank Bob Doris for his amendments to address concern about high rates of spoiled ballot papers in some council wards. It's clear that more needs to be done to assist voters in expressing their views, especially in council elections. In its Stage 1 report, the committee asked the Government to bring forward an amendment to make clear that election pilots could encompass automatic voter registration. I was happy to work with Mr Doris at stage 2 to achieve just that. At this stage, I cannot provide an absolute commitment to a full pilot on automatic registration. We will, though, continue to work closely with colleagues in the Welsh Government to monitor progress and consider how we can pick up the lessons from the activity they have underway looking at automatic registration. We will also continue to work closely with the UK Government on work to improve registration, given their ongoing responsibility for Westminster elections. That said, I am happy to commit to the Scottish Government leading work to run a specific trial on more automated forms of registration, with a particular focus on improving registration levels amongst young people. At stage 2, Ross Greer brought forward helpful amendments to make clear that our Democratic Engagement Fund could be used for the purposes of automatic registration at education institutions. We will seek to take forward a pilot of that nature. I envisage the Scottish Government and electoral registration officers working directly with interested schools, further higher education institutions and local authorities. And I'll be happy to report back in due course to say how we have got on with seeking to take forward such a pilot. I'd also like to thank Ross Greer for the further changes today in respect of boundary reviews and electronic voting, and also the amendment requiring a study on the merits of randomised names on ballot papers. At stage 2, Ben McPherson helpfully raised the question of whether MSPs should have to be ordinarily resident in Scotland. I have written to those members and the committee with plans for further consultation this spring. That is in addition to the consultation I have already mentioned. This will include proposals on residency requirements and candidate deposits for MSPs, removing some types of council by-election and further issues on disqualification from office. And as I've just referred to, I'll be publishing another consultation with the aim of doing so in January on the issue of dual mandates and bring forward regulations informed by that consultation, which will bar MPs and members of the House of Lords from also being able to simultaneously be an MSP. It's fair to say that this bill might not have attracted significant attention previously, but when the matter of dual mandates came to the fore, it certainly brought it into the foreground. The debate on this matter has allowed us to take action to address an issue where many hold strong views, whilst also affording time to get the finer details correct. I express my thanks again to Mr Simpson for his work on this area. President Officer, the electoral process does not begin or end on polling day. Months of planning are involved, not just by candidates but by electoral administrators too. For over 15 years, the Electoral Management Board has provided invaluable assistance and support to returning officers and others in the conduct of our elections. It was central to ensuring the safe and successful holding of elections during the pandemic. We are building on the success, rightly ensuring the next steps in the EMB's evolution by enshrining it as a corporate body with an improved constitution under the direct oversight of the Parliament. The Electoral Commission is another vital part of the electoral landscape. This bill will ensure there is a stronger link to this Parliament in planning and reporting on its activities in our elections. Let me conclude by expressing again my thanks to all those who have engaged on the bill. Together we have, I believe, agreed a robust set of improvements to the law, which, should we pass the bill today, it will, I hope, deliver real benefits to voters. I move that the Parliament agrees that the Scottish Elections Representation and Reform Bill be passed.
Thank you, Minister. I now call Annie Wells, around 6 minutes. Ms Wells.
Thank you, Presiding Officer. The Scottish Elections Representation and Reform Bill followed a consultation that was launched by the Scottish Government in late 2022. This consultation focused on administration and governance, election scheduling, candidates, voting and campaigning and finance. It was through this consultation that many initial productive exchanges were had between MSPs and stakeholders. For instance, the plans to allow 16 and 17-year-olds to become councillors and MSPs was dropped after widespread opposition and concerns became clear. The bill is now, though, being welcomed by a host of organisations, either in whole or in part, such as the Electoral Reform Society in Scotland. The Society's Senior Director, Mr Willie Sullivan, even described the bill as a tidying up of Scotland's electoral system in January of this year. Support for the bill, like this, resets on the common desire to have our electoral system continually updated to meet current and future needs of voters. My Scottish Conservative colleagues and I agree that laws surrounding electoral issues are not static, and we have continually supported this bill's aim of creating a more efficient and transparent electoral system. Given that the 2026 Holyrood elections are just around the corner, these aims couldn't be more relevant both to us as MSPs and the public. I support the aims of the bill, but it's worth looking at exactly what it sets out to change to make this updated Scottish electoral system a reality. Provisions cut across various areas of electoral law and would, for example, make the Electoral Management Board for Scotland its own separate legal personality as a corporate body. Other changes include expanding who can propose an electoral pilot scheme to improve democratic engagement, and further provisions, Presiding Officer, would allow the Presiding Officer of this Parliament to propose an election date that is either 4 weeks earlier or 8 weeks later than typically held. And notably, the Electoral Commission would be subject to changed requirements to present 5-year plans. These plans would detail the intentions of the Commission alongside requirements for resources pertaining to devolved functions in Scotland. And I am certain that I join colleagues from across the Chamber in welcoming the progress that has been made since the start of the process of this bill. And while I acknowledge the progress that has been made so far and it is an encouraging sign of things to come, I do have concerns about the bill, and I am not alone. The Law Society, while supportive of parts of this bill, has also expressed reservations about the practical challenges of some of its provisions. Their concerns focus on proposals to allow non-citizens living in Scotland with limited leave to remain to run for public office. And, Presiding Officer, I do not believe that those who have been subject to a sex offenders notification requirement should ever be allowed to hold public office, regardless of level. And I do not think that this bill currently goes far enough in helping to ensure that. This was why I brought my amendments forward, both at Stage 2 and Stage 3. The Stage 3 ones would legally require any candidate to declare if they had ever been subject to a sexual harm order, risk order or notification requirement in the nomination papers. And I absolutely understand the Minister's concerns over this, that it would be in breach of the European Convention of Human Rights, and I do take that on board. But for me personally, I think this is a missed opportunity, and is unfortunate not only for anyone who agrees with me, which I can safely say, as quite a lot of people that I've spoken to, but this fails to... Yes, absolutely. Minister?
I mean, I've already made this point. I completely understand and appreciate the concerns that any person, including her and any other person, would have about the reservation they would have with any individual with a history of sexual offending standing for elected office. I would reflect the points that Mr Whitfield made in that regard in terms of the responsibility of parties around who they nominate. But would she accept, would Ms Wells accept that while she may feel the bill does not go far enough, that the changes we made at Stage 2, where people can now be prohibited from holding office, either in this place or in local government, if they've got a sexual offenders notice or order, is a significant improvement where we are now?
Annie Wells. Minister, yes, I absolutely do agree with that. But what I'm saying is I just don't think the voices of victims of sexual offences have been heard throughout this passage. And I welcome the Minister's response to me, and I know we all sort of share the same concerns, but it was how did we get that into legislation, and there just wasn't a way to do it, and I appreciate that. But to conclude, Presiding Officer, the Scottish Elections Representation Reform Bill has been several years in the making, beginning with the extensive consultation launched by the Scottish Government on electoral reform in 2022 to this point we here today. We are much closer to changing our electoral system for the better and making it fit for the future. Admittedly, while this bill is not completely exhaustive in its aims, as alluded to in the concerns I had just highlighted, I think the provisions it contains broadly achieve them, and steps are in the right direction towards more comprehensive changes. And moreover, the Scottish Government is expected to introduce secondary electoral reform legislation next year, or regulations, with the intent to have proposals ready for implementation in time for the next Holyrood election. I will work constructively with colleagues from across the chamber when it comes the time, and I very much look forward to looking at the secondary regulations carefully with the same goal in mind. To create a more transparent and smoothly run Scotland, whenever people across the country go to the polls to choose their representatives, is the right thing to do. Thank you, Presiding Officer.
Thank you, Ms Wells. And I now call on Martin Whitfield to open on behalf of Scottish Labour. Around 5 minutes, please.
I'm very grateful, Deputy Presiding Officer, and it is a pleasure to open this debate with the bill that has haunted me since I almost came into this Parliament. But like others, I would like to start by thanking my colleagues on the committee, but also those that have supported the committee in the form of the clerks, and also Spice for their knowledgeable input. And I'd also like to thank those who gave evidence, both to the original consultation that the Scottish Government called between December 22 and March 23, but also those who contributed to the committee's evidence at stage 1, and indeed insisted us with ongoing evidence on the very fundamental and complex issues that arose during consideration of disqualification. I'd like to thank the Minister for his positive open-door approach, and I hope he feels that that was replicated as far as I was able, both as convener but also as representative of Scottish Labour on this matter. And I would also like to echo him with his thanks to George Adam, who opened up that original consultation with "bring me anything you can think of," and people obliged. And it then became a vehicle of trying to restrict and bring into something, because I think it's interesting that a bill that was introduced on only the 23rd of January 2024 finds itself at the close of this year in a position where, hopefully, it will become statute. And to look back at that original policy memorandum, which suggested a number of improvements to the law affecting Scottish Parliament and Scottish local government elections, it certainly has achieved that. In the short time that I have, I would like to address again the amendments that Annie Wells brought, and also her contribution at the committee stage. It is a challenging element of this, where rights are restricted and the knowledge that should be open. But I think it talks to the iterative nature that election bills need to be. And actually, these are bills of this Parliament as much as they are bills of the Scottish Government. And although some may not agree with me, I envisage it's not going to be overly long before we have to look again in the form of primary legislation. And in between that, we have the secondary legislation. So if I have any criticism of the Scottish Government, I would draw attention to the role of secondary legislation in particular in this field, and the extent to which the Scottish Government feels it will be able to go to that area and decide what it wants. And I look forward to hearing from the Minister on that, if not necessarily this evening, at a near date in the new year. During the amendment stage, Keith Brown raised the challenges of dual mandate, which I think were very eloquently debated at that stage. But one thing that was not mentioned, which I think is worth mentioning, is the challenge of having two elections, one for a Scottish seat, be it at either council level or indeed here in this Parliament, and also to have one with a UK election, is that we use very different electoral methods. And the historic example of where we tried to do that at the same time categorically showed the challenge of doing that. So there is always a cost element. We must take that into account. But there are also the electors and what their expectation is. And we are aware, both in the recent election to this place and earlier, that in fact incorrect instructions have been given. So voting, election law, is an iterative process. In the very short time I have left, I would like to make mention of a number of other matters that haven't been so far debated. We touched on the complexity of campaign finance, particularly in Scottish elections, and the role of third parties and third assisters, and the fact that this is a very complex area, which I think it would be foolish for anyone to believe that we fully understand and have got our heads around, because it's an ever-changing field, and I think the mention of the elections in the US points to something that we need to look at. The election pilots have been talked about at length, and they are a huge step forward to allow tests in the real world with the proper restrictions, with the proper control, but also open to those who are knowledgeable about this to bring forward. We haven't mentioned today digital imprints, which is a massive change in the way that members in this chamber and indeed across Scotland will interact with the electorate, and the requirement for the electorate to understand what is happening. We touched on the boundaries changes, which make sense, and also the Electoral Management Board for Scotland taking place as a corporate body, which is important. So, in conclusion, this is an iterative step, but it is the right step to take on the 25th anniversary. It has not all been easy. There are complex issues that it's been highlighted. We are pressing into secondary legislation some very important decisions, which I know this chamber will oversee properly and fully. The government would expect no less, and actually the electorate would demand no less from us. But it is still an ongoing discussion to find the best method, because elections are not just the morning when it opens at 7 a.m. and goes through to 10 p.m. It is all the weeks and the months that go beforehand, from engaging young people to ensure that they're registered to vote and that they want to vote, engaging people who are of an older age who may never have voted to come back, to raising the numbers of people who vote in certain areas. All of this is the responsibility of anyone who seeks election. It is also the responsibility of others that in this bill have been empowered to do that. I'm grateful, Deputy Presiding Officer.
Thank you, Mr Whitfield. I now call on Ross Greer to open on behalf of the Scottish Greens. Around 4 minutes, please.
Thank you, Presiding Officer. I said earlier when moving amendments on aggravators that our democracy is under significant pressure. I think the choice facing all elected representatives and parties at the moment, not just in Scotland and the UK, but across most of the democratic world, if not all, is whether to exploit divisions for personal or party advantage, or to defend the fundamental principles of a democratic society. And maximising participation minimises the opportunities for negative, hostile actors to undermine trust and legitimacy in our elections. I think this bill, in so many respects, is welcome. I'm reminded of a phrase that a colleague of mine has used a lot previously, that politics should be something that the public feel we all do together, not something that's done to them by politicians, and too often it feels like the latter. And following on from Martin Whitfield's closing comments there, I think 25 years into devolution is the right point to consider pretty fundamental questions of reform. And in that respect, the bill does make welcome, but I think limited progress. I think there was an opportunity here for major reform, and I don't want that to be mistaken for any frustration with the bill itself, that the progress that's in there is very welcome. But, for example, earlier this year there was some debate, mostly by MSPs but outside of this place, around the size of Parliament. There were 129 MSPs in 1999, there's 129 now, but we have far more power and responsibility than we did before, and there are significant issues of capacity, both for the government to have the required number of ministers, but then for Parliament to have enough MSPs and enough capacity to effectively scrutinise the government and the wider public sector. There were proposals made from different parties and indeed the presiding officer on that very issue. Yes.
Martin Whitfield.
I'm very grateful to Ross Greer to take an intervention. And on that very point, should election bills, should election law not sit as an animal of this Parliament rather than the Scottish Government? We have capacity through committee bills and others, but could one of the iterative moves to look at that, so that as a chamber that we can address election challenges coming down the line?
Ross Greer.
I'm very grateful for that intervention, and well, I do think there's a role for government, particularly in a lot of resolving a number of administrative issues around elections. I think as a matter of the health of the democratic system, having wider issues of electoral law and electoral reform sit primarily with Parliament would be very welcome. If that's Mr Whitfield perhaps hinting at his committee's interest in future committee bills in that area, I would certainly welcome it. I will take an intervention from the Minister, though.
I mean, this is a point that came up at stage one, and I think I was pretty clear at that point, Presiding Officer, the government would absolutely welcome Parliament taking the lead on these matters. So what I would suggest, with great respect to those members who are concerned about doing so, is get on with it.
Ross Greer.
I'm very grateful for that intervention from the Minister and that outbreak of consensus, which I think has been a pattern this afternoon in a number of areas, perhaps on this one with different motivations in mind for the different parties involved. I moved a number of amendments in Stage 2 to address long-standing democratic deficits, barriers to participation. I thank the committee for their patience with the sheer number of amendments that I brought forward. Some of them were recommendations from the Electoral Commission that had long gone undelivered. Others were policies long advocated by external organisations, and some were just from my own experience as an election agent, a campaign manager, a member of staff for a party, and of course as a candidate. And I'll cover some of those in closing. There's just one that I want to highlight now, and that's on the matter of safety for those involved. And it's not on aggravators. It's an amendment that I moved at stage 2 that saw unanimous support that I'm very grateful for, around simply removing no longer requiring election agents to publish their address. And that was based on the experience of an election agent in my party who had an individual turn up at their door seeking the elected representative that they had been the agent for the Saturday after the election. Now, fortunately, it was an individual who you might describe as overly enthusiastic rather than dangerous, but that was nonetheless extremely alarming for that election agent. I think it's a small but simple example of the range of measures in this bill that are going to improve our democratic system. So despite some frustrations that I have around, I think, a missed opportunity for more substantive reform, I'll be glad, and the Scottish Greens will be glad, to vote for this bill this afternoon for the great many necessary changes it makes to our electoral systems.
Thank you, Mr Greer. And I now call on Alex Cole-Hamilton to open on behalf of the Scottish Liberal Democrats. Around 4 minutes, please.
Thank you very much indeed, Presiding Officer. I think it's been an excellent debate, and it gives me pleasure to offer the support of the Scottish Liberal Democrats to the bill before us, and as I hope it passes into an act of this Parliament. Before I properly begin my remarks, I think, as others have done, I want to pay tribute to the committee, the work of the committee, those who are involved in the evidence sessions, and indeed the officials around the bill who often go unsung. I'm pleased that this bill commands broad support across the Chamber. The changes that we're discussing today may seem little, but they're necessary. And I think they speak to our custodianship of our democracy as we leave it for the generations of parliamentarians that will fill this chamber to come. Democracy is the worst form of government, as Churchill said, but except for all the others. I think what he meant by that was that it's imperfect, and it is imperfect. And as new technologies come online, new realities about our changing population, about how we view the world, then it is incumbent on us to reflect those changes in the pages of the legislation that we pass in this place. I'm particularly pleased that this legislation will extend candidacy rights at Scottish parliamentary and local council levels to people of limited leave to remain. 4 years ago, this Parliament, I think rightly, granted refugees the right to vote in elections in Scotland. It's only right, therefore, that if we are going to extend the franchise, then they can stand in those elections. My party also... Yes?
Minister.
I mean, just at stage 1, we heard some concern expressed about enabling such individuals to stand. But would he agree with me that it's perfectly possible for such individuals to stand in an election, and to put themselves before the electorate, and for the electorate to decide the merits of whether or not someone with limited leave to remain can represent them adequately?
Alex Cole-Hamilton.
Very grateful for the Minister's intervention. I think he makes the point very well, that actually this place is made better, I think, by the richness of diversity of views and life experiences that we each of us bring to this chamber. I can think of no more deserving voice that we do not hear enough of in this chamber than that of somebody who has sought safe harbour and been given sanctuary in our country. I think they would seek to serve their community as ardently as anybody that is elected to this Parliament so far. And I think those people that are concerned about that really should defeat that argument in open ground. Stand against these candidates if you're worried about them representing your community, and let the people who we trust with so much in this Parliament be the final arbiter and judge of that. My party, as I expressed in my very brief remarks, are supportive and have been supportive of the amendments passed in the name of Graham Simpson to prevent dual mandates, to prevent the so-called double jobbing. This is a privilege. This job is a privilege. It is all-consuming. If you let it, it can destroy your quality of life, your pastimes, and sometimes even your family. I would urge members not to let it do that. But the idea of being able to somehow hold an equally pressing job in an institution several hundred miles from here is just completely alien. I'm glad that we've finally boxed that off. I think it was an aberration of the devolution settlement that we've solved today. So while I'm gratified by the progress we're making today, we shouldn't lose sight of the things we still have to do. Going forward, I think we do need to look at a more robust system for breaches of the ministerial code. We touched on that slightly in the statement that came before the stage 3 proceedings of this legislation, Presiding Officer. We also need to give voters, fundamentally, the right to recall their MSPs as they are so afforded in Westminster as well. Liberal Democrats also want to see, as I have said several times in this debate, an answer to the question about how we verify the suitability of elected members, whether they're in this chamber or in our council chambers, to run the very delicate work of supporting very vulnerable individuals at a time of need, and whether that is through protection of vulnerable groups or a bespoke scheme, it remains an unanswered question, and I worry and regret that we may be forced to answer it after something terrible happens. I don't think we should wait for that. We need to do more. I think we would all agree to encourage the representation of underrepresented groups in this Parliament, whether that be women, LGBT plus minority communities, disabled people, black and minority ethnic groups. It is vital that everybody in our society has a voice in our nation's Parliament, and they are reflected in its makeup. We also need to encourage people from every background to get involved in the democratic process just by engaging, by coming out to vote. We should all be pleased that voter turnout at the last Holyrood election in 2021 was the highest since this Parliament's inception, 63%, but it still means that thousands of people are not engaging in the democratic process. I can see you would like me to come to an end, Presiding Officer. I am pleased to offer the support of the Liberal Democrats today. It's been, I think, an uncharacteristically jovial and positive debate. Let's have more of this, and I'm glad to offer our support today. Thank you.
Thank you, Mr Cole-Hamilton. And we now move to open debate. I have two members seeking to speak. Speeches of around 4 minutes. I call Rona Mackay to be followed by Richard Leonard. Ms Mackay.
Thank you, Presiding Officer. I'm pleased to be speaking in this important debate, which is so crucial to democracy and transparency. The Scottish Parliament, rightly in my view, agreed not to consent to the UK Elections Bill in 2022, as it's for our Parliament to legislate on electoral law in Scotland for our local and Holyrood elections. As a recent substitute member of the Standards Committee, I had some catching up to do in the detail of the bill, and I hope I managed to capture the crucial elements today. So, as we've heard, the bill introduces provisions to expand candidacy rights, protect candidates and campaigners from intimidation and improve administrative arrangements for elections in Scotland. In what I understand was a largely consensual committee process, and always the best kind, the Minister has worked to bring together all points of view to accommodate different opinions in most areas. Indeed, he stressed an open-door policy in which all views would be considered, and I think they have been. This legislation has seen improvements during scrutiny, including amendments at Stage 3, that will allow the issue of dual mandates to be addressed before the 2026 election, an issue which has hit the headlines recently. On this important issue, the Scottish Government has been clear that it is supportive of ending the practice of dual mandates, where MSPs are also able to be MPs or peers. However, it should be noted that the issue was not really discussed at Stage 1, and there has been no consultation on the issue, which is why provision to introduce secondary legislation has emerged in the amendments at Stage 3. The Scottish Ministers have now committed to holding a public consultation to allow political parties, COSLA and the public to provide views on dual mandates for MPs, peers and councillors prior to the 2026 Holyrood election. Presiding Officer, this bill is an opportunity to create an electoral system that improves democratic engagement, including for those who have chosen to make Scotland their home. This is hugely important in my view, and I agree wholeheartedly with Alex Cole-Hamilton's comments. The bill extends candidacy rights in Scottish Parliament and local government elections to foreign nationals with limited leave to remain. This ensures that all those who live in Scotland can play a bigger part in our democracy. And that is an important signal, welcoming all those who choose to make Scotland their home. This is an especially important reform for EU citizens in Scotland who had their democratic rights removed by the folly of Brexit. Presiding Officer, the bill proposes important changes in a number of areas requiring action, including candidacy, voting and electoral administration. And it also extends the 2022 UK Election Act disqualification order to bar those found guilty of offences involving intimidation of campaigners, candidates and elected representatives from being MSPs or councillors. Additionally, it creates a Scottish disqualification order which will apply to people found guilty of offences involving intimidation of electoral workers. The legislation makes changes in relation to spending in election campaigns, including the definitions of notional expenditure, overseas spending and third-party campaigning. And those changes broadly match those made by the 2022 Act for UK Parliament elections. Learning from recent lessons, the bill proposes measures based on the experience of COVID-19 to allow elections to be rescheduled in emergencies, and that's an absolute necessary future-proofing measure in my view. The bill revokes the existing Scottish regulations on digital imprints, but adds to the new rules applied under the 2022 Elections Act. To support innovation in elections, we've also heard it allows pilot schemes to be brought forward by the Electoral Management Board for Scotland and electoral registration officers and Scottish ministers. And the bill creates a power enabling the Scottish Government to fund efforts to increase democratic engagement across Scotland. Presiding Officer, another aspect of the bill are the boundaries changes. I don't have time to explain that. But I think we're all agreed that this bill is a huge step forward and makes an important difference to the democratic rights of voters in Scotland, and it puts voters first in its programme of electoral reforms. Thank you.
Thank you, Ms Mackay. And I call Richard Leonard. Around 4 minutes, please.
Thank you, Presiding Officer. And can I begin by reminding Parliament of my voluntary register of trade union interests? Next year marks the centenary of the birth of the great parliamentarian, the great democratic socialist, Tony Benn. His view was always absolutely clear that in a democracy, sovereignty belongs to the people, and they merely lend their power to those who represent them. With a stubby little pencil, he used to say, attached to a piece of string, voters can put a cross on a ballot paper that will remove an MP from Parliament or a government from power without killing anyone. Hard won by the trade union movement, by the Chartists, by the suffragettes, these are democratic rights which history teaches us we have to keep battling to defend and to advance. So I welcome the fact that we have extended the voter franchise and that today we are extending the candidacy franchise too, because I agree with the simple principle that those who can vote in elections should be allowed to stand in elections. Although it is worth recalling that when Jenny Lee was elected in the North Lanark by-election of 1929 as the youngest woman MP ever at the time, at the age of 24, it was before she was even old enough to vote. In contrast, I reject the argument that we have heard expressed during the passage of this bill that somehow allowing asylum seekers to stand for election, that extending civic rights, somehow opens up the possibility of abuse from foreign powers, presumably as sleeper agents undercover, maybe brainwashed a la the Mancunian candidate. I think this is far-fetched. In fact, we should be much less worried about the overseas infiltration of our politics via this futuristic dystopian plot than we should be worried about the present-day overseas-funded infiltration of our elections and our referenda by dark money and the super-rich. We should be much less worried about electoral fraud by people who care for and accompany voters with additional needs into our polling stations than we should be worried about the disenfranchisement of people because of digital exclusion, or as a result of Boris Johnson's law requiring voters to produce an identity card. We should be much less worried about extending voting rights to people who are detained on mental health grounds than we should be worried about the integrity of our very democracy, in effect, lying in the hands of the owners and the chief executive officers of gargantuan, predominantly US-based technology corporations. Dark money, digital disinformation and dirty politics, that is the very real and present danger we are actually facing now. And that is why I support all attempts in this bill to tackle this, to improve transparency, to curb digital disinformation and to introduce better checks and balances on third-party campaigning. So we welcome this bill. We will be voting for this bill, and it is right that we see how best we can end the dual mandate The total abolition of the House of Lords would be one step forward. But finally, democracy cannot only be about voting in elections. As George Eliot presciently wrote 150 years ago in Felix Holt the Radical, a novel on the early days of Chartism, all the schemes about voting and annual parliaments are engines only. The force that is to work them must come out of human nature. This is the people's democracy. We have to be its guardian, we have to be its defender, and it is our duty to ensure that that force of human nature is nurtured, is encouraged, is liberated and is put to work for good.
Thank you, Mr Leonard. We will now move to closing speeches, and I call on Ross Greer to close on behalf of the Scottish Greens. Up to 4 minutes, please.
Thank you, Presiding Officer. I'd like to start by thanking all the external organisations and individuals who contributed to this bill and made it stronger through those contributions. If I have a small note of frustration there, it is though that there are some organisations and individuals who've had a lot to say about electoral reform over recent years, but barely had anything to say in this process, or who were entirely absent for it. And I think that it was poorer for their absence, because I found myself agreeing with many of the things that they had said in the past. And I know it might come as a surprise to those of us in here, but some people don't find legislating to be quite as much fun as campaigning. But it is incredibly important, and I would urge those who have had a lot of compelling cases to make around electoral reform to engage with the consultations, the many consultations that are going to come about as a result of this bill. And on that, a number of the amendments that I moved at stage 2 but didn't press to a vote will now go to consultation. I'm glad the Government has agreed to that. One of them was to deliver an Electoral Commission recommendation from 2015 to remove cash deposits. And it might seem a little bit odd that I would have moved that, given that my party, bluntly, can now finally afford to pay deposits to stand in most places. But I moved it because, as the Electoral Commission noted, it is wrong to place a financial barrier in the way of people participating in elections. Now, of course, some kind of threshold is absolutely required. What we proposed instead, which is common in other jurisdictions, is to be nominated by a certain number of registered voters in the relevant area, the constituency or the region. I'm grateful to the Minister for agreeing to put that forward for consultation. There were other amendments that I moved in that similar space of democratic reform, one around replacing council-level by-elections with nomination of replacement candidates or replacement councillors where a councillor had to vacate their post. That's simply replicating the system that a number of other countries who use STV have, to recognise that a single-member by-election for a multi-member ward often distorts the result and results in a number of people going without the representation that they had chosen at the point of the election. I found it interesting on that one that I had a number of members from different parties speak to me outside of the committee proceedings about that, to either strongly agree with or oppose it, and there was no pattern based on which party they were from, the positions that they took on that. I think that reflected a lot of the issues that we addressed in this bill. I'd like to thank Ben McPherson for raising the issue of residency as a candidacy requirement at stage 2. I think it is a shame that we couldn't agree to that. I don't think it's a controversial statement to say that you should be resident in Scotland to stand for election to the Scottish Parliament, and I hope that, while that's not going to be the case for the subsequent, for the next election in 2026, that it will be subsequent to that. This bill builds on a very strong legacy, I think, of electoral reform in this Parliament. Votes at 16, voting rights for refugees, which I was reminded of in the last few weeks due to recent events in Syria and the downfall of the Assad regime. Because at the 2021 election, I ran into two friends of mine, Syrian refugees, who voted at the same polling station I did, who were folk who I'm sure wouldn't mind me saying, both middle-aged people who, for the first time in their life, were casting their vote in a free and fair election, because this Parliament decided that they, as residents of this country, had just as much right to have a say in who governs this country as any other resident. And I would contrast that legacy of electoral reform here with the UK government's, previous UK government's record on the introduction of voter ID, an entirely unnecessary requirement. In closing, I'd like to thank the Minister and the Bill team for their cooperation, Graham Simpson, of course, for his incredibly important amendments, George Adam for the approach he took in kick-starting this process. And I'd like to not just agree with Alex Cole-Hamilton, but to agree with Winston Churchill, not something that I do very often. But Mr Cole-Hamilton's reminder of that famous Churchill quote that democracy is the worst system apart from all the others. It is indeed a messy and a difficult way to run a society, but it really is the only way that is worth trying. As I said earlier on, politics should be something that we, the people, all do together, not something that is imposed on the public by politicians. And I'm glad this bill takes us that little bit further towards that eventual goal.
Thank you, Mr Greer. I now call on Martin Whitfield to close on behalf of Scottish Labour. Up to 4 minutes, please.
I'm very grateful, Deputy Presiding Officer. And I think the quality of the debate that we've had in the last 40 minutes or so actually underlines the quality of the interaction and the cross-party nature, actually, that the election bill has brought. And I very much welcome Rona Mackay to the committee and to her contributions. And I agree that we reached consensus and we did so reasonably well. I think when we disagreed reasonably, which is perhaps a skill that if we saw elsewhere, people would look less disrespectfully sometimes at this chamber. But we also sought solutions to the problems that were confronted. It brought to us by people from outside who were bringing evidence to evidence sessions, also in the nature of amendments that came forward, because there are solutions to the problem. And I think, to echo Richard Leonard's speech, the real challenge is what sits outside looking in and an attack at the democracy that they see, the fear they have of democracy, the ability they have with large sums of money, almost irrespective of campaign finance rules within an election, can, if they choose to do so, overturn that. And I also think it is worth reflecting on the nature of people who are exercising their voting now. And we see in the UK general election the rise of a new political party that manages to speak to the electorate, so they're coming out at council elections that we've already heard have very low turnouts. And I think it sits as a responsibility on us all here to challenge that, to take truth to the people, to say that what they have in front of them are options of different ways to, quite often, an agreed goal. That is a better country to live in. The Elections Bill has at times been very challenging, and I want to again reiterate my thanks very selfishly and very specifically to the clerks of the committee who put up with some frustratingly silly questions from me and took time to make sure I actually almost understood what sometimes I was asking other people to do, because we stand here supported by groups of people around us without whom so much of this would be massively challenging. But in conclusion, I want to talk about voters themselves, the individuals who go pick up the stubby pencil, often still attached with string, or sometimes feel that they wish to take a pen because of concerns about the system, to do that individual thing within a booth, which is to cast a vote. The pilots hopefully will allow us to look at people who, instead of voting 1, 2, 3, put a number of X's. Those who choose to express their views in an artistic form that perhaps doesn't result in a vote being counted, but does sometimes bring slight amusement at the table at the far end of the counting hall with arguments about exactly who they're expressing an interest in. So, conscious of time, and so that hopefully we can reach decision time at the appropriate moment, can I once again thank all of those members across here who interacted with the committee, took time to come forward with points and ideas. And I would go back to what I said in my opening, that this is an iterative process, and I may well take up the Minister on his offer expressed to this chamber to get on and do it yourselves. We may take that with enthusiasm. I hope he doesn't regret that offer. But I think in formulating a democratic system that perhaps is the best of the worst, we actually can move forward so that people feel that this once again is their parliament, that people feel that their council is their council, and that the people who represent them truly do represent them. I'm grateful, Deputy Presiding Officer.
Thank you, Mr Whitfield. And I now call on Sue Webber to close on behalf of the Scottish Conservatives. Up to 5 minutes, please.
Thank you, Presiding Officer. As Scottish Conservatives, we understand that electoral policy doesn't stand still and that this bill will update the law in time for the 2026 Holyrood election. Electoral reform that improves the running of the Scottish elections and at the same time makes our democracy more transparent is very welcome. And I want to thank the Minister for working closely with us throughout Stage 2 and Stage 3. Although my colleague Annie Wells' amendments were not pressed to vote, it has been important that we were able to share and debate the issues she has presented to us in the Chamber today. And Martin Whitfield earlier acknowledged the challenges with balancing the various rights in terms of that. I don't believe that sex offenders should ever be allowed to hold public office regardless of that level. And I do hope that at some point that the Government may take the bold step of reviewing this really complex issue, as I don't believe it's one that can be ignored. I want to briefly touch on the amendments that focused on dual mandates, whether that be for councillors, MSPs, MPs or members of the House of Lords. And I'm quite relieved that these will first have to go to consultation for a better understanding of the unintended consequences that they might have, and that some of them may progress no further than this. And again, Martin Whitfield mentioned some of the pragmatic elements in terms of costs as well, in terms of having elections running concurrently with the different electoral methods and different incorrect instructions that have happened in the past. And I certainly hope that any consultation on this will be open and fair, and that views will be accepted without any prejudged conclusions. I had a dual mandate for a period of 12 months. I was a councillor for Pentland Hills Ward in Edinburgh, whilst I was a regional MSP for the Lothian. It was a genuine privilege to do both, and I believe that there wasn't a second in that period that I let any of my constituents down, either as a councillor or as an MSP. Perhaps, Mr Cole-Hamilton, because it wasn't miles, hundreds and hundreds of miles away, and it was just up the hill. But indeed, I don't think I would ever have become an MSP had I not been a councillor first. And my involvement in local government was a great place to gain experience and cut my political teeth, while letting me stay heavily involved in my local community and learn more about what other opportunities in politics exist, such as being an MSP or an MP. If this was no longer possible, I know that this Parliament would suffer missing out on a diverse range of potential MSPs. And a lot has been made about the double jobbing and taking double pay whilst elected representatives do these dual roles. As an Edinburgh councillor, the payroll system made it quite straightforward for me to arrange for my councillor's salary to go directly into 2 nominated charities within the Pentland Hills ward, without the money ever coming to me or my bank account at all. And it was an honour to support these 2 charities for the period of 12 months. And I know that from the feedback that the money was spent locally supporting families and individuals directly in need. The Minister pointed out some of Bob Doris's amendments that spoke to the high rates of spoiled ballots, and Martin Whitfield's spoken about some of the animations that we all see. But we also heard about Ross Greer's ideas about compulsory registration, or automatic rather, get the terminology right. There was so much that we heard today that went on before the discussions this afternoon, and I think that really goes some way to, as Mr Greer pointed out, maximising participation will enhance the trust that people have in politicians, and I think that's something that's really, really in need of. We're all needing that to be restored quickly. So with the Scottish Government introducing further electoral reform legislation next year in readiness for implementation in time for the next Holyrood election, we will work constructively with colleagues from across the Chamber when the time comes, as we have done. And the Minister spoke of the many planned consultations, and I do hope that this will be managed to ensure that they are really successful in terms of engagement, and that the Council don't get consultation-itis. The public, I'm not sure what word I said there, I was getting mixed up. It is, after all, in all of our interests to create a more transparent and smoothly run Scotland, where the people across the country go to the polls to choose their elected representatives. And the Minister called it Parliament's bill. So to conclude this afternoon's proceeding, I would like to formally state that the Scottish Conservatives will support the Scottish Elections Representation and Reform Bill. Thank you, Presiding Officer.
Thank you, Ms Webber. I now call on Minister Jamie Hepburn to wind up the debate. Up to 6 minutes, please.
Thank you, Presiding Officer, and I begin by thanking all those who have contributed today to set out a wide-ranging and positive set of contributions. I think that reflects a constructive dialogue throughout the parliamentary process, although, can I say, I was rather surprised to hear Martin Whitfield at the outset of his contribution saying that this is a bill that has haunted him. I don't know if that's because we are approaching the festive season. I've never thought of him as an Ebenezer Scrooge-esque figure haunted by any form of spectre. So I hope the successful passage of this legislation will exorcise him of any haunting sensation that he has hitherto experienced. Annie Wells mentioned the collective desire that we have to have an electoral system constantly updated and being refined and improved. I very much agree with that. I would also reflect that this bill has been refined and improved over the period that has been taken through Parliament. That in itself has served to better refine and improve our electoral system. She also said electoral law is not static, and I agree with that. And indeed, that's why we have already indicated the activity that will take forward. That's why through that process of not recognising electoral law as static, that I've announced the Government intends to carry out 2 consultations on issues raised throughout this bill. In January, I will publish a consultation on the detail of dual mandates ahead of introducing regulations in autumn, informed by that consultation, which will bar dual mandates for MPs and peers also being MSPs. Rona Mackay, whose remarks about my willingness to engage with others I very much appreciate and I thank her for, but she did really speak to the necessity of that form of consultation, because effectively what that's designed to do is we've established our position in respect of what we should do, but we need to get it right. Although I should say, in relation to Mr Leonard's remarks, I very much agree and concur with him about the best way to deal with any prospect of a dual mandate for any member of the House of Lords is his preferred solution. I also have a solution as to how we could end the practice of dual mandates of MPs and MSPs, and that would be Scotland not sending anyone to serve in the House of Commons but become an independent country. And I look forward to Mr Leonard coming to that same conclusion in due course. I also will publish a second consultation in the spring on issues such as residency requirements, deposits, by-elections and disqualification. Those arose frankly as issues out of amendments coming forward at stage 2. I hadn't planned on taking forward such a consultation, but having been proffered as suggestions earnestly, I have determined that we should look at that further and will take forward that consultation. And I've already spoke of the plans to have a review of the boundary setting process, which does indicate that we are likely, and Martin Whitfield made this point, we are likely to return to the need for further primary legislation should we seek to introduce any form of automaticity, and I'll give way to Mr Whitfield. Martin Whitfield.
I'm very grateful to the Minister to give way and to return to, if not my haunting, my favourite of automaticity with regard to boundary review. It is the case that we do need to fall in line with the rest of the democratic world in relation to the boundary justifications. I look forward to the Government's proposals on that consultation and indeed, if possible, the primary legislation either in this session or in the very near future to see that come about.
Minister.
Well, in the interest of transparency, I think it's very unlikely that any legislation will be this session, but we will take that forward as soon as possible as a review process, and I will, of course, make sure that Mr Whitfield's committee is kept appraised. On the issue of around who should have responsibility for the activity in terms of refining our electoral process, is it the legislature by comparison to the executive? The exchange that there was between Mr Greer and Mr Whitfield. My intervention on Mr Greer might have seemed a little supercilious, but it was not meant to be entirely. I do genuinely make the point that I would welcome proposals emerging from Parliament, and Mr Whitfield is very welcome to come and speak to me about any proposals he suggests I might regret it. I can quite assure him I'll be less Frank Sinatra in my way and much more Edith Piaf in terms of disposition. I did that just so I could mention Frank Sinatra, because the Manchurian candidate was mentioned earlier by Mr Leonard, so I thought he deserved a mention. But the Government does have a role, nonetheless, in this process. Candidly, Government has probably more capacity than Parliament might have in terms of taking any form of reforms in terms of electoral law forward. But what I will say, and what I hope the process of this bill demonstrates, is that I am more than willing, within reason of course, to ensure that the capacity the Government has can be utilised by members of the Scottish Parliament to make changes to electoral law. That capacity exists, and if people want to discuss issues with me, including the composition and the size of Parliament, as Mr Greer mentioned, I should say that was not a proposition that he or anyone else brought forward for this bill. I'll be candid and say I welcome that. That would have probably overshadowed any debate we had on dual mandates, it has to be said, Presiding Officer. But if members want to bring forward other ideas, then I will be happy to engage with them. Presiding Officer, let me conclude by again thanking members for their contributions and the important progress we all seek to take forward in developing our democracy. This bill will improve and modernise Scottish elections and take important steps to safeguard our democracy for voters, candidates and administrators alike. But voters in particular, I was taken with the quote that Mr Leonard made, quoting Tony Benn, that sovereignty belongs to the people and they merely lend it to those who are elected. I fundamentally agree with that, and this bill only serves to preserve that principle. And on that basis, Presiding Officer, I commend this bill to Parliament and I hope we will now move on to pass it.
Thank you very much. That concludes the debate on Scottish elections, representation and reform bill at stage 3. It's now time to move on to the next item of business, and there's one question to be put as a result of today's business. And the question is that motion 15875 in the name of Jamie Hepburn on Scottish elections, representation and reform bill at stage 3 be agreed. And as this is a motion to pass the bill, the question must be decided by division, so there will be a short suspension to allow members to access the digital voting system.